Mr. President, Your Excellencies, distinguished colleagues and friends, it's really a true pleasure to welcome you to this very special event on the United Nations War Crimes Commission. A warm welcome also to those of you who are joining us online. It's really lovely to do this in collaboration with our partners, the Embassy of the Republic of Poland at The Hague, the Pilecki Institute in Warsaw, SOAS London, and the University of Warsaw. The UN War Crimes Commission looks at its 80th anniversary, on 20 October. So this is really, I think, a reason to look back at its record. I think the UNWCC has very much been an institution ahead of its time. It's not so much talked about in our daily conversations in The Hague, but it's been really a hub of transnational legal thought. It has been the port of entry for investigations, collection, and evaluation of evidence of crimes committed during World War II. And it's been instrumental, of course, to the establishment of a permanent international committee. It has paved the way for over 2,000 trials in domestic courts of allied powers, not only in Europe, but also in Asia. So it is to some extent maybe also a counterexample to the Western-centric critiques of international criminal law, saying that international criminal law is an all Western product. The Soviet Union obviously preferred to maintain a distance, but it's often forgotten that also Russian jurists like Aaron Trining provided important impulses to the work of the Commission. So before the background of contemporary conflicts, it's of course really useful to look back at this record. We have Dan Plash with us, who has gone through all of the archives in London, and he has published a wonderful book, Human Rights After Hitler, The Lost History of Prosecuting Exit War Crimes. And together with Professor William Scheibes and Dr. John Powderly, we've been editing a symposium on the work of the Commission as well a couple of years ago. And it really shows that the legal practice of the 1940s is really much more complex than we usually assume, which really many discussions on rape, on conspiracy, on attacks of heritage, on maybe early definitions of genocide already occurring in the work of the Commission. And as Philip Sands or Kerstin von Lingen have brought out in their research, the history of the UNWCC really demonstrates how much international criminal law as a field is also based on the transnational circle of lawyers. So I think that's one of the important lessons also for us to draw today. So today we don't only want to go into the past history, we want to make connections to today, to crimes against minorities, children, heritage crimes, and this is just the tip of the iceberg. So many things, I think, to Paulina Ducek, who's very modestly there behind in the back, Dominika Uciewicz, Patricia Gribich, and Katie Hoon, who have been really the driving forces also about getting us all together and making this really important event happen. Patricia has also just published an important article, which I would encourage you to read, on the crime of aggression against Ukraine, the role of regional customary international law in the European Journal of International Law. So I think we can look forward to some very exciting discussions with our excellent panelists. And without further ado, I'm now happy to give the floor to Her Excellency Margareta Kasanga, Ambassador of Poland to the Netherlands. Thank you.
Good afternoon. My name is Margareta Kasangana, and I'm the ambassador of Poland to the Kingdom of the Netherlands. Excellencies, distinguished representatives of the international courts and tribunals, ladies and gentlemen, dear colleagues. It is my great honor and pleasure to welcome you at the international conference marking the 80th anniversary of the establishment of the United Nations War Crimes Commission, a little-known UN agency that played a vital role in preparation for the war crimes trials that followed the Second World War. The Commission's aim was to study the indictments submitted by individual states and to draw up lists of war criminals that would serve as a basis for their extradition. Its role was also to advise any government wishing to consult the Commission on any issues relating to war crimes. The work carried out by the UNWCC was dedicated collective effort underpinned by desire to prosecute war criminals. As you know, Poland was the country the most affected by atrocities of the World War II. War crimes were not only committed against Polish citizens, but also against other nationals on Poland's territory occupied by Nazi Germany. Therefore, already during the war, the Polish nation consistently demanded the punishment of war criminals and made great efforts to document their crimes. Already in 1943, the Polish government in exile established the War Crimes Office, which was headed by a jurist, Jerzy Litacki. Its role was to advise the Polish advance the Polish agenda on war crimes in two ways. First, by participating in the United Nations War Crimes Commission's plenary and subcommittee deliberations, and second, by submitting charges and dossiers for alleged war criminals. The office was represented at the UNWCC by, among others, Stefan Glaser and by Tadeusz Cyprian, Polish outstanding lawyers, the latter of whom was also a talented photographer whose photographs were used for the purposes of the criminal proceedings. According to UNWCC records, 1,535 cases were submitted by Poland, including 372 concerning crimes committed against the Jews. And these were the first cases of this type. Ladies and gentlemen, before the creation of tribunals in Nuremberg and Tokyo, tribunals in Rwanda and Yugoslavia, before the establishment of the International Criminal Court, whose president is with us here today, welcome Professor Hochmański, there was the United Nations War Crimes Commission, whose work and achievements deserve our attention and careful analysis. Therefore, together with our partners on this special occasion, the 80th anniversary, we decided to invite the most distinguished experts to discuss the Commission's achievements, not only in the historical dimension, but above all in the contemporary context. What lessons can we draw from its work today? Sadly, today, the work of UNWCC seems to be very relevant. Today, we are still confronted with immense human suffering in different conflicts throughout the world. When preparing the conference program, we decided to focus on specific challenges related to atrocities that are being committed in Ukraine, 600 days after Russia's invasion. Thus, one of the panels of our conference is specifically devoted to that subject. To conclude, I would like to thank our panelists and moderators for accepting our invitation and honoring our event with their presence. I also thank our audience for coming in such a big numbers, and also those who are watching the conference and participating online. I wish you a successful and fruitful discussions. Thank you very much for your attention.
Dear guests, ladies and gentlemen, I'm Christian Bicher. I'm representing one of the organizers, the Pilecki Institute. So I just wanted to introduce the institution to you. And I'm really pleased and honored to be part of this fantastic endeavor commemorating the 80th anniversary of UNWCC. Just to mention, in February this year, we have organized and hosted a conference in Berlin entitled Russia Russia's war of aggression against Ukraine, challenges of prosecuting and documenting war crimes, and I'm really glad to see many familiar faces from this conference here today. So welcome, thank you for that. And it was already what much was said about the UNWCC here, and it will be said during the conference. So I don't want to take much of your time here in the introduction, but let me mention just a few things which we as the institute are involved in. So I don't know if you are familiar with that there is only 3 places right now in the world which hold the whole collection of UNWCC documents. Of course, one is the webpage of Professor Flash, but we have the Wiener Holocaust Library and Washington Holocaust Memorial. And the third place is the Pilecki Institute. We have the whole collection accessible online also, so you can access all the documents through our web pages. So please, if you're interested, do it. So our today's conference is already the second day in which we are organizing together with University of London. So and we are working together on some mutual projects which will soon announce some scholarship programs. So if you are interested in researching UNWCC and accessing the documents, it will be the right address to check. So soon, I mean, in the time frame of 1 month, there should be an announcement about the scholarship program. So please keep checking our webpage. I would just like to mention that we are privileged to be in a research center in Warsaw, which is dealing primarily with Rafał Lemkin heritage. I mean, most of you are familiar that Rafał Lemkin was a Polish-Jewish lawyer, a prosecutor in the interwar period, and of course he survived Holocaust and left for the United States, and he's most famous for his Genocide Convention of 1948, but we had, for example, a 5-year-long project which was trying to show the roots of Lemkin, because he was a very well-established prosecutor during the interwar period in Warsaw. So here, this is one interesting result of this project will be a book coming out soon, printed by Routledge Press. So in a few months, it will be a new biography of Lemkin, documenting and analyzing, especially the first early years of Lemkin, which was not done so far. So if you are interested in this topic, please also look forward to for this book. And I have to mention at the end, and because I don't have much time, so maybe there will be more opportunity during the conference and breaks, that the Pilecki Institute has established in February 2022, just a few days after the Russian invasion of Ukraine, the Lemkin Center for documenting Russian war crimes in Ukraine. And it's we have collected already several thousands of testimonies, but I have to stress, because there are many lawyers here, the aim of the Lemkin Center is not to collect evidence for future legal proceedings, but it's different. It's to collect testimonies, documents for scientific and journalistic research and investigations, just to give voice to the victims, to give voice and to spread the knowledge about the Russian occupation of Eastern Ukraine to the general public, and not only in Poland, of course, but in the whole world. So we are working on this project. If you are interested in joining us, if you have any interest in documenting war crimes, I mean, there is several projects right now. For example, the Reckoning project you may be familiar with, from Peter Pomerantsev and Janina Dzidziwiani. They also work for documenting for legal issues, for legal process, but also for the memorialization of the victims, yes, and making the broader public aware of the crimes which are happening there. So without further ado, I would like to pass the voice to Professor Flash. Please, the floor is yours.
Thank you so much, distinguished colleagues, Your Excellencies, eminent judges, ladies and gentlemen. It's fantastic to see everybody here today as we continue to look at the relevance of this body from the Second World War to the conflicts which tragically we still have to look at today, and whether it's Israel-Palestine or Ukraine, the relevance is, I think, great. My work has been mentioned once or twice. I had a long-standing background in investigative research, and just over 10 years ago, in looking at the historical origins of the UN, I came across this body, and the clue was in the requirements to access it, which were that you had to get personal authorization from your government, personal authorization from the United Nations Secretary General, and then on reading it, you were not to be permitted to make any note or copy of what it was that you read. Now, there's room there for a little satire, perhaps, but this indeed was the reality. There's a long story over beers or reception. I can unpack that. But in the end, we discovered that although one or two very good quality publications had been published in the 1940s, that almost the whole archive had been sealed until I, with some colleagues, insisted upon and got support to have it opened. And what we found was, as my colleague Wolfgang Form called in a great article, a treasure trove of state practice, case law on the issues of war crimes. What one might say in the context of the ICC, a dynamic system of positive complementarity. That is a system of states coming together collectively to support and examine the domestic prosecutions of individual countries, which is something which we grope towards today. But this was a system in London under Nazi bombs and missile attack, where they had these meetings, not so different perhaps to Kiev today. It came about, first of all, one should, and this is fantastic to have such Polish leadership, because of the leadership of the Polish exile government in London and General Sikorski. And those of you who study this subject, if you attack the footnotes, as historians we like to, you find that there is something called the Declaration of St. James's of the beginning of 1942, which is Sikorski's leadership. And there they say, he says, we are going to win. After we win, we have to have international legal support in order to prevent mob rule and vengeance. We have to have legitimacy. A vital point, I think, as we go look at the world today. And they're blunt enough to say, with new crimes, we need new laws, we need new legal processes. And from that point on, they started to develop their work. And who were they? As an Anglo-American, I have to say the Anglo-Americans were sitting on their hands. They never really fully supported this. It's a miracle we ever got to Nuremberg, I think, looking at the record. But it is the exile governments of Central Europe and Eastern Europe who led, and very unfashionably, the nationalist government of China, who led the way, with some support from India. And indeed, there was an Ethiopian War Crimes Commission. Not that the Western powers were too keen, but in the end, even Ethiopia got cases against the Italian fascists heard. And who organized this? And who ran it? Was it just an ad hoc, hole in the wall, kangaroo court system? Well, it's an argument, I suppose. But take Sir Cecil Hurst, those who study international law, one of the founders and architects of international law as we know it. He had been president of the International Court of Justice here in The Hague in the 1930s. And he is its first chairman. And in the end, the Anglo-American bureaucrats get rid of him by the end of 1944. Then I will bring my remarks to the end very quickly, because he is pressing and has a document with a constitution for International Criminal Court, because he and his colleagues are campaigning for crimes against humanity. And back in Washington, they are concerned that this might get in the way of lynching African Americans, according to some of the notes we found. So he and his American counterpart are pushed aside by their bureaucracies. But nevertheless, the work continues, and particularly, as I will address later, on the issue of the prosecution of a head of state by another state. Now, we have the position of the International Court, and I will discuss this later. But frankly, one might say they might have done their homework a bit better before their judgment of 2002. So those are the players, those are the processes. And as you see from this chart, if we look at the World War II prosecutions and those which is the very thin sliver of the cake, and we look at those of since 1990, which is the yellow sliver, the large part of the pie chart are the cases that the UN War Crimes Commission considered as prima facie evidence brought by these member states, and which then, which we now know, resulted in some 2,000 trials and 10,000 convictions. And I close on this because I think one of the problems of inheriting the Nuremberg model, 20-odd people in court, well, because they only had 20 seats, was the reason it was that number, as others could remind us. But the idea of producing convincing, compelling cases against thousands of low-level and mid-level perpetrators is something that the international community struggles with today. And yet, at a time of far less resources, of far greater stresses and strains in the international system, we found the political will to do so. And if there's no other reason for recommending its work to you, it's because of that fact. And you do not get case files against 36,000 people just because of a few intellectuals and judges. You get it because the people want it, because the evidence is brought forward. And we're seeing that in Ukraine, where there are thousands and thousands of dossiers. So if you're looking at the need for large-scale prosecutions of mid and low-level perpetrators and think you have to start from scratch, you don't. We and our member states did it before, and therefore we can do it again. So thank you very much, and you're welcome to the conference.
Welcome to our first panel today. My name is John Cornell. I represent the Pilecki Institute, and it's my honor to be the moderator of this panel. I wanted to just say a few very quick words. We are today commemorating the 80th anniversary of the founding of the UNWCC, 20th of October, 1943, well, 80 years and a couple of days. And 1943, of course, seems very late in the game for this sort of thing. But so I think it needs to be stressed that, in fact, work towards the establishment of such a body for the purposes of finding adequate legal as well as political responses to the accumulating crimes of the Axis powers was really, in fact, begun long before that date. And really, in fact, as soon as the exiled governments of Europe began to gather, first in France and then in London, along with this rich international community of legal experts, demands for addressing the Nazi war crimes and the question of their future punishment were being constantly made, and one declaration after another. As Dan already mentioned, the St. James's Declaration, for example, particularly by those most affected, by, for example, Poland and Czechoslovakia and the World Jewish Congress. And the deliberations that began in those early years of the war, which would eventually coalesce into the UNWCC, were of course themselves only really a continuation of debates, conferences, declarations, and treaties that stretch back all the way to the Hague Conventions and the Geneva Conventions of the previous century. And of course, they continue on today and will probably continue on for years to come. So the UNWCC is really just one step within this long continuum of works towards codifying and strengthening international criminal law. In this panel, we'll be talking about how the United Nations War Crimes Commission functioned and a little bit about what it accomplished in its time. We'll also perhaps, I hope, speak some about the political constraints and difficulties that the UNWCC faced. It was, after all, as Dan indicated, primarily politics that brought it to a premature close in 1949, and which kept it hidden from view until Dan came along. And then finally, we'll also consider whether the accomplishments of the UNWCC have been superseded by current institutions of international law and justice, and whether there is still much that it can offer us as a model. Our arrangement will be to have brief 10 to 15 minute presentations from each of our panelists, and then I will let them perhaps discuss amongst themselves and ask questions of each other, and then I'll open it to the audience. So perhaps we might begin with Dr. Dominika Uczkiewicz, who is a lawyer and historian, whose research interests lie in the field of transitional justice, legal history, and German-Polish relations, with a particular focus on the history of international criminal law and of war crimes trials after the Second World War. She currently works as an assistant professor at the Center for Totalitarian Studies at the Pilecki Institute in Warsaw. Her recent publications include Polish and German perspectives on transitional justice, World War II and its aftermath, a volume edited together with Wolfgang Fromm, who will also be speaking with us, and more recently a monograph on the war crimes policy of the Polish government in exile in London, published in 2022, which will soon be appearing in English. Dominika, hand the mic to you, yes. Manage that. Let's stretch.
Thank you.
Go forward a bit, perhaps.
Thank you, John, for the introduction. It's a great honor for me to contribute to today's discussion on the legacy and history of the United Nations War Crimes Commission. In my presentation, I would like to shortly describe the structure of the Commission, the historical context of its establishment, and to focus on the contribution provided to UNWCC works by the representatives of occupied countries, to also address this Western-centric critique towards Nuremberg trial style tribunals in the history of international criminal law. The UNWCC and its have new perspectives and records in that area. 20 October 1943, when the works of the UNWCC were officially initiated, marks a landmark in the development of principle of common war crimes policy of allied countries during the Second World War. Before that date, the representatives of occupied countries, the members of 9 governments in exile that were based in London during the Second World War, in many ways attempted to alert the international public about the large-scale atrocities committed under Nazi rule and unprecedented crimes against the civilians. The other goal was to gain support from Western powers for the idea of prosecuting and punishing individuals for violations of international law. These attempts included international information and media campaigns on the situation of civilians in occupied territories, protest notes, publications of white books, different reports, but also debates on the question of accountability for international crimes and on the architecture of post-war justice. The names of 2 expert bodies that were established in 1941 in Great Britain are to be mentioned here. The London International Assembly and the Cambridge Commission for Penal Reconstruction and Development. These associations have conducted advanced comparative studies on the issues related to the prosecution and punishment of war criminals, continued the debates on the development and empowerment of international criminal law from the interwar period, and also have strengthened the network of lawyers involved in this circles. Another landmark was the already mentioned Declaration of St. James's Palace that was announced on the initiative of Polish and Czechoslovak governments in exile on 13th January 1942. The declaration was the first official resolution announced by the Allies. that was government of 9 occupied countries, outlining the principles of prosecution and punishment of individuals who commanded or directly perpetrated breaches of international law. The declaration condemned the German conduct of warfare, the violations of the Fourth Hague Convention, and particularly addressed the large-scale persecution and extermination of civilians in that conflict. Its goal was to guarantee effective jurisdiction of the over war criminals on national and international level, and to guarantee the surrender of the perpetrators of the effective trial after the end of war. The Declaration of St. James's was important foundation of the common war crimes policy of allied countries. It put particular focus on the necessity of documenting war crimes and identifying the suspects. In spring 1942, the declaration's signatories have established another expert body, that was Inter-Allied Commission on the Punishment of War Crimes, which was responsible for documenting Nazi crimes and conducting information campaign. The US and British governments have not joined the declaration of findings in the works of the Inter-Allied Commission, but as international network supporting the investigations and focusing on the question of effectiveness of future war crimes trials and cooperation in collecting relevant evidence, the Inter-Allied Commission paved the way for creation of the UNWCC in October 1943. United Nations War Crimes Commission main task was to develop the legal and operative standards for collecting evidence of crimes committed by occupying forces and to provide member states with legal assistance in questions related to the prosecution of perpetrators of international crimes. Given this wide range of responsibilities and the commitment of Commission's members to its work, the Commission has developed a very complex approach towards the issue of accountability, which was mirrored in the Commission structure. On the slide, you can see the pictures of two chairmen of Commission's chairmen, Sir Cecil Hurst and Dodge White, and also the structure of the body. The first committee on facts and evidence, under the chairmanship of the Belgian representative Marcel de Beer, was responsible for examining the charge files and evidence submitted by each country. This committee was responsible for the pre-trial validation of documentation of international crimes and supported the states in conducting investigations. But the Commission itself didn't possess any investigatory powers and mechanisms to document the crimes by itself. The Committee on Facts and Evidence has developed and implemented an uniform system for the presentation, transmission, and assessment of cases, and compiled a list of alleged war criminals. By the end of its works in March 1948, Commission has assessed a total of over 8,000 charge files and compiled 80 lists of war criminals, which were used by the Central Registry of War Crimes and Security Suspects. The second committee on means and methods of enforcement, which was chaired by the American representative Herbert Pell, focused on the technical aspects of prosecuting war criminals, the questions of extradition and surrender of the suspects, but also of documenting the crimes which means could be applied, but also of criminal procedure of post-war trials. In 1944, the Committee on Means and Methods of Enforcement has drafted a statute of United Nations War Crimes Court, an international tribunal with jurisdiction of the international crimes subsidiary to the national courts. I think this question will be discussed today in detail for the structure of this tribunal, this project. So I would like to address two names in this context and in the draft of a statute of inter-allied court that was prepared by Marcel de Boer and other members of the London International Assembly in 1942. The Dutch delegate, Johannes de Moor, who was chair of the subcommittee on the defense of superior orders at the Cambridge Commission for Penal Reconstruction and Development, and Dutch representative to the London International Assembly and to the UNWCC, was one of the authors of this draft. The second person involved in this project was Professor Bogdan Winiarski, professor for international law at the Poznań University, member of the Polish government in exile, and after the war, judge and president of the International Court of Justice. Coming back to the structure of the UNWCC, the last committee on the legal questions was chaired by the Polish representative, Professor Stefan Glasser. And this chamber was responsible for analyzing the legal issues related to the prosecution and punishment of war criminals and discussing the admissibility of cases submitted by member governments. The scope of this discussions on the definition of war crimes, crimes against minorities, the definitions of crimes against humanity, and also the question of liability for war of aggression were discussed and addressed during the debates within the third committee on legal questions. Here on the slide, you can see one of the first proposals to define the scope of works of the UNWCC, prepared by Marcel de Boer. And one of the definitions of crimes against humanity is involved here. And around these topics, their works were focused. Next to Marcel de Boer, the chairman of the first committee, and Stefan Glasser, the two lawyers I have already mentioned, I would like to raise your attention on Bohusław Eger, the Czechoslovak representative to the UNWCC, who was also committed to the issue of penalization of the crime of aggression and provided definitions of crimes against humanity and advocated for including this new type of violence, new international crime into the scope of Commission's works. Another crucial issue or one of the main issues discussed within the legal committee discussions was the question of individual liability for international crimes, and touched upon the questions of the act of state doctrine, the sovereignty of states, the issues of immunity of states, head of states and state officials, and acts committed upon superior orders. Stefan Glasser, the Polish representative to the Commission, was highly devoted to the issue of establishing the rules for determining individual liability for war crimes, the same as Bohusław Eger and Stefan Glasser. Okay. With these three portraits and names and their involvement into the Commission, I wanted to underline the role that smaller states, their representatives, and experience of war, which was mirrored in the cases submitted to the Commission, to legal projects and proposals presented during the discussions, were crucial and decisive for resolutions developed by the UNWCC and the legal standards developed for the future prosecution of war criminals, and the important role and contribution of lawyers from smaller, usually Central and Western and Eastern European states to this agenda. Thank you very much for your attention.
Thank you very much for that, Dominika. Next, we have Dr. Amina Adana, who is a lecturer, assistant professor in law in the School of Law and Criminology in Maynooth University, where she teaches and researches in the area of human rights law. She publishes in the areas of international justice and Irish property law. Dr. Adana's research interests lie in international law, specifically in the area of domestic prosecutions of international crimes and the history of international law. In 2018, Amina was awarded a PhD in human rights from NUI Galway for her doctoral thesis entitled Allies and Enemies, Past and Present, an analysis of the rationale for the development of universal jurisdiction over serious crimes under international law. Thank you, Amina.
Thank you, John. Good evening, everybody, distinguished guests, Mr. President, and it's a pleasure to be here today to mark the 80th anniversary of the UN War Crimes Commission. So my presentation starts with the general overview of the UN War Crimes Commission and its structure. I also then focus on the Commission as an early example of positive complementarity, before then exploring its legacy, its successes and its limitations. And then I conclude by exploring the entities today that may have subsumed some of its functions. So we all are here today to mark the 80th anniversary of the UN War Crimes Commission, which was, of course, established in the British Foreign Office on the 20th of October 1943 by the representatives of 17 allied nations. It was the only post-war international mechanism that addressed prosecutions for international crimes where the trials themselves took place on a national level. It had the status of an international organisation and it operated from 1943 to 1948. The Commission's main task was to investigate allegations of war crimes, to record evidence of the crimes and to identify the perpetrators. During its lifetime, it created over 8,000 files representing nearly 37,000 individuals and groups, not to mention the conclusion of 2,000 trials. One of its main purposes, of course, was to achieve a level of post-war preparedness for the trials that would take place or prosecutions that would take place, something that didn't manifest in the aftermath of the First World War. Considering its relatively short lifetime and its limited resources, including its small budget, it's remarkable how much this commission achieved, or this institution achieved, in such a short time frame. Notwithstanding all its achievements, which will be highlighted today, no doubt, its prominence continues to be overlooked by the IMT at Nuremberg and in Tokyo, respectively. It has been described by one eminent scholar as the best kept secret in international criminal law. Although the fact that we are all here today, and given the ever-increasing scholarship on the topic, I really do hope that it is now well out in the open. So looking to a general overview of the Commission, I won't spend too much time on this because I know Dominika already spoke about the work of the various committees. But it is important to note that in particular, Committee 1, in terms of its gathering of evidence and information of the Commission of International Crimes, this was facilitated through a network of national offices that were created in each of the member states. Now, some 15 of the 17 member states did go to the trouble of creating these national offices. So it was the national offices that conducted the investigations in their respective states and submitted the information to Committee 1. Where it was the case that the committee one felt that the evidence that it received from the National Office, if it didn't reach the standard of a prima facie case, in that case, then it was up to the National Office to locate more evidence where available. Committee 3 in particular is really important to note in terms of some of the issues that it addressed that are still relevant for us international criminal lawyers today. So issues such as crimes against peace, the definition of crimes against humanity, extradition, extraterritorial jurisdiction, and as notably as Professor Dan Plesch and Leah Owens note in a forthcoming article, Committee 3 adopted an early definition of the crime of denationalisation, which would today be more along the lines of the crime of genocide, and that was submitted by Poland. Once agreed and adopted by the UN War Crimes Commission, the standards and concepts that were asserted by particular Committee 3 were then put to the national offices and to the governments of the member states, and in many cases the recommendations of the Commission were followed and in others not followed. So there's no doubt that this relationship between the organisation, the Commission and the national offices, that it is a form of early, what we now call positive complementarity. But it was this relationship that was key to the functioning of the institution. Notably, the national offices were also encouraged to transmit information that they gathered to other member states where it was relevant for trials in other member states. In addition to that, it's important to note that the Commission also prompted member states to enact laws criminalising international crimes in their respective states. And along those lines, some of those countries did adopt extraterritorial jurisdiction, including universal jurisdiction, incorporated into their national laws. So reflecting on the legacy of the UN War Crimes Commission, by now we're all familiar with the statistics and the numbers of the Commission, but it is a prime example of early mutual legal assistance between the member states. It facilitated the exchange and transfer of knowledge between legal experts and countries, governments, and also knowledge exchange between various international bodies at the time. Dominica already noted the overlap between the Commission and the likes of the Cambridge Commission and the London International Assembly. In addition to that, it's important not to forget that the Commission also had, and its writings of its scholars, it influenced the definition of crimes in the Nuremberg Charter, and as I mentioned, it did address these legal questions, some of which that we still grapple with today. For that reason, it's important not to overlook it as a source of customary international law. It has the records, the archives, the summaries of trials, the reports that were produced under the UN War Crimes Commission provide a wealth of information and source of opinion juris and state practice. At the same time, it's important not to overlook the obstacles and limitations to the Commission. So this self-reporting system whereby the national offices submitted information and evidence to Committee 1, to the Commission, was an impediment at times to the functioning of the Commission, and particularly when in the early days of the Commission, when the flow of information from the national offices was slow. In addition to that, the representatives of the respective member states on the Commission, in particular the US representative Pell and the British representative Cecil Hurst, they were met with disagreements from their respective states. And particularly when they looked at the definition of crimes, including the scope of war crimes at the time and the definition of crimes against humanity. And unfortunately, the Allied States won that battle. In addition, it's also important to note the lack of uniformity in the laws and state practice between member states, particularly when you look at the laws that were enacted in the context of those that provided for extraterritorial jurisdiction or universal jurisdiction, which some states, for example, the UK, in its royal warrant of 1945, it limited its jurisdictional scope to prosecute war crimes rather than crimes against humanity, for political reasons. Some states also chose to focus on prosecuting their own nationals who had collaborated with Nazi regimes during the occupation as well, and that's evident in the case law of some other cases. So the question arises, what aspects of the functioning of the UN or the Commission, UN War Crimes Commission, have been subsumed into various international institutions that exist today? Professor Carsten Stan has noted in his article in the Criminal Law Forum from nearly 10 years ago that international criminal justice is still in search of a modern UN War Crimes Commission 2.0. So in some sense, I think we are definitely getting closer to that achievement, should it happen. So some examples that we can perhaps elaborate on in our panel discussion afterwards would include the EU Genocide Network, which is a network of member states and including EU member states and also observer states such as UK, US, Canada and the International Criminal Court. And in addition to that, the network also has membership of associate status, where civil society organisations such as Amnesty International, Trial, the ICRC also participate in this network. But this network is again facilitated through a number of contact points in each of the respective states, where there is a level of expertise amongst law enforcement officials in terms of I suppose the investigation of and prosecution of international crimes. And the idea here again is to allow for more mutual legal assistance between countries to facilitate prosecutions. It's also important to note that the Genocide Network also cooperates with the recent mechanisms that were established to investigate the Commission of International Crimes in Myanmar and Syria, respectively. A more recent facility within the EU Genocide Network is the creation of joint investigation teams, whereby member states are able to work on cross-border common concerns in this area. And they've been quite productive in recent years. A joint investigation team was established between France and Germany in respect of the prosecution of senior Syrian officials in 2018, and that actually led to the prosecution of Syrian nationals in Germany in the Koblenz case. So there is that link between establishing these sort of networks and it leading to a subsequent prosecution. More recently, a joint investigation team was established between Ukraine and Poland and other countries with an interest in prosecuting suspect war criminals within those countries. To a certain extent, particularly when it comes to ideas of having a central repository for a database of evidence of the commission of international crimes. The two mechanisms that were respectively established to look at the commission of war crimes in Syria and Myanmar fulfill that role. Obviously, part of their duty is to investigate the commission of international crimes, gather the evidence, interview witnesses, preserve that evidence, and obviously then share that evidence with states who are conducting such prosecutions, and also with international criminal tribunals. Just before I finish up, a more recent example of mutual legal assistance that is very relevant when we talk about whether or not the UN War Crimes Commission's mandate has been subsumed into other institutions is the very recent Mutual Legal Assistance Treaty, which was agreed on by 76 states in May of this year. That will come into force once 3 countries have ratified the treaty, and obviously there's a time frame that applies to when it comes into force after that. But that also establishes a network of contact points between states that sign up to it. It's a very detailed treaty. It, on a micro level, it engages with what happens with data that is submitted, or the question of data protection, that is what happens to the data that is submitted to that initiative. And on a macro level, it achieves a real level of communication between the contact points. So it definitely is very, very promising indeed. So on that note, I will finish up. Garev Mila Mahagot, Dziękuję, and thank you all for listening, and I look forward to your questions after.
Thank you very much, Alina. Okay, last we have Professor William Chavez, who is well known to everybody, Professor of International Law at Middlesex University in London. He is also Emeritus Professor at Leiden University and the University of Galway, Honorary Chairman of the Irish Centre for Human Rights, and invited visiting scholar at the Paris School of International Affairs. Professor Chavez is also a door tenant at the Chambers of 9 Bedford Row in London. He has appeared as counsel before several international and national courts and tribunals, including the International Court of Justice, the International Criminal Court, and the Grand Chamber of the European Court of Human Rights, and the Supreme Court of Canada. He is author of more than 20 books dealing in whole or in part with international human rights law and international criminal law. Bill, the floor is yours.
Thank you very much, John, and it's always a great pleasure to be back here at Leiden University. For many years, I've lectured in this very classroom here. President Opmansky, Excellencies, esteemed colleagues, dear friends. Let me try to add a little bit to this portrait of the United Nations War Crimes Commission, talk a little bit about its establishment and composition. The point has already been made that this was an institution where smaller countries, we focused on the countries of Central and Eastern Europe, but I think it's important also to recognize, it would be a shame here in the Netherlands, not to acknowledge the great contribution that the Dutch made, the Belgians, and the French. Annie Cassin was one of the participants in the United Nations War Crimes Commission. Still, it was very much of a British initiative, to be quite blunt about it. The British was there, they promoted the idea. Churchill went to the United States and discussed it and agreed with Roosevelt in 1942. And then it took them about a year to pull all the pieces together and to organize this famous meeting that took place in London on the 20th of October, 1943. Not everybody was there, and the big piece that was missing was the Soviet Union. There had been negotiations, and we have a paper trail of this in the British archives, with the Soviet government. The problem with the Soviet Union was that they wanted to send more than one delegate to the commission. And they argued with the British. They said, listen, you're not just coming as the British, you're bringing your friends, Canada, New Zealand, Australia, South Africa, and India, the British dominions, and they said, you're going to have 5 votes. We should have the same number. And they said, actually, we'll be willing even to welcome Burma, but on the condition that you welcome Ukraine, Belarus, the Baltic states, and I forget the name of it, Karelia, which was occupied Finland at the time. And the British refused, absolutely. And this was never resolved. So it was just left there hanging. It never went to the commission itself, or the members of the commission were asked, would they agree with this? It was just the British were running things, and they took the decision, and they basically ignored it. So the Soviets were on the periphery. So were the Canadians, by the way, who did not join with Australia, New Zealand, South Africa, and India. I've looked through the Canadian archives, not been able to find any sufficient explanation for why. Although what I did find was all of the papers of the United Nations War Crimes Commission. So I haven't made them public, but I've had the documents since the 1990s because I found them. The Canadians kept a set in the archives of the proceedings, of the minutes and so on of the UN War Crimes Commission. The commission was established as a fact-finding body. It was very clear that it wasn't there to get involved in the actual organization of prosecutions. And this very quickly became an issue for the members of the commission, because they said, well, logically, this has to lead somewhere, and they started working on this draft statute of an international court. And it's really one of the ancestors of the Rome Statute of the International Criminal Court. And they agreed on a draft in October of 1944 and sent it on to the British government, to the foreign minister, Anthony Eden, for his, they said, it's up to you now to convene a conference where this will be negotiated and discussed. And Eden sat on it for about 3 months and then wrote back saying, that's okay, we don't agree with this, and it's not going anywhere. And it didn't go anywhere, the project. And that brings us back to October of 1943, when the commission was actually, it had its first meeting, I think, 5 days later on the 25th of October. There were a couple of preliminary meetings, and the formal first meeting actually took place in January of 1944. But a week after, and if you'd like, we could come back, Carson, next week and have another conference on this. A week after, on the 1st of November, 1943, the Declaration of Atrocities, which was a part of the Moscow Declaration, was adopted by the British, the French, by the British, the Americans, and the Soviets. And it too dealt with prosecution, but it dealt with the issue of how. And it said that the prosecutions were to take place generally by the courts of the countries where the crimes took place, except for the major war criminals whose crimes had no specific geographic location. And they said, we reserve the right, the 3 of them, we reserve the right to determine where those prosecutions will, how that will take place and where that will be done. Just as an aside, there's one other detail that is not very well known, but it may be of interest to the people in the room here today. The original version of the Moscow Declaration referred to Nazi atrocities, including, and I quote, the wholesale shootings of Polish officers. So this was adopted on the 1st of November, 1943. The mass grave of the Polish officers had been discovered in Katyn earlier that year, discovered allegedly by the Germans, and was only just at the point where the Soviet armies were about to retake that part of what's now Belarus today. So it was the version out there was, of course, the German explanation that it was the Russians who'd done it, and the Russian answer that this was just Nazi propaganda. It's not clear whether that was a mistake, because in the versions that were later published, it refers to the wholesale shootings of the Italian officers. And you can find both on the internet if you go looking, both versions. The version with the reference to the Polish officers is the one that the British published. And the people in the Foreign Office questioned this and said, there's a problem here. They said, and they had protests from the Polish representatives in London saying, you know, you shouldn't be saying that because it's not clear that the Germans killed the Polish officers. They checked with Churchill because he had been in on the final draft, and Churchill said, no, that's okay. But the Soviets said, well, that's a mistake. It should be the Italian officers. So it's a mystery. It's a mystery that I can't unravel for you, and I've never seen anything where anyone's ever figured out exactly what happened. The Americans published the version with the Italian officers. Originally, they published the one with the Polish officers, and then they retract. So if you shudder when you see the reference to the Polish officers being murdered by the Germans, you should look for the other subsequent version, and maybe you can find the apologies.
Yes.
Now, back to the British, and the reason why they wanted to reserve what happened to the major war criminals, because the British didn't want to put them on trial at all. They wanted to execute them summarily. And Churchill was very attached to this view, but why they wanted to reserve, British didn't want to put them on trial at all. They wanted to execute them summarily. And Churchill was very attached to this view, but wrote quite a lengthy memo on this where he set out his views. And there's a wonderful phrase in there where he says, we have to avoid the, quote, tangles of legal procedure. And they debated this, but it's very hard to find any evidence of any serious objection to this within the British government. And they maintained that view until the beginning of May of 1945, when the San Francisco conference had already begun. And there was a meeting in the margins of the San Francisco conference to resolve between the Soviets, the Americans, and the British. And I don't know if they yet invited the French to the party, but it was those three, and they had to decide what they were going to do about the major war criminals. Clearly, the British, the French, the Soviets and the Americans wanted a trial, and the British representative at San Francisco cabled back to London, and he said, you know, give me some instructions, because they're not bending on this, and nobody else seems to like the idea of summary execution. Churchill spoke about a list of 50 to 100 people who would be executed, and the people in the Foreign Office actually prepared lists of the candidates, many of whom appeared on the bench in the box at the Nuremberg trial. But some others who aren't there, something that's always intrigued me is that on this list of 50 to 100, Adolf Eichmann is not there. And this was an issue in the Eichmann trial when people said he was the worst of the Nazis and he should have been, and others said he was an insignificant figure. And I'm not going to pronounce myself on where he fit in the spectrum of atrocity, but it's striking that he didn't make it onto the list. Let me just say a few words now about the relevance of UN War Crimes Commission. Carsten Stan asked me if I'd say a few things, a few ideas about it. Of course, it's interesting historically, but I think questions remain not just about the UN War Crimes Commission, but also about the modern day equivalents of these investigation bodies that have been referred to for Syria and Myanmar and so on. I'm not convinced that they actually deliver what they're supposed to deliver. I don't think we have the evidence. I'm even skeptical that we really have the evidence for the UN War Crimes Commission. Yes, it's probably true that they send evidence to be used in court. And I remember I questioned recently someone who worked with the Syria Commission and said, is it useful? Does it deliver? And they said, oh yeah, we helped the prosecution in Germany. But saying that you helped the prosecution is not the same thing as saying we produced decisive evidence that made the difference between a conviction and an acquittal. And I think that we should have more, we should be more convinced of that before we jump headfirst into the idea that these are wonderful institutions. I think that they need to demonstrate that they actually gather evidence that's decisive, that's significant, that's important. And the other point is that they have to be able to demonstrate as well that these have been gathered according to our modern standards of gathering and evidence. And what I mean by this is we have an article in the Rome Statute, Article 54, that instructs the prosecutor to gather evidence both for and against conviction. In other words, like an instructing magistrate in a continental justice system. And this is not something that prosecutors are used to doing in all parts of the world. And I think that maybe in the international institutions that are gathering evidence today, that it's not also very clear that they're gathering evidence both for and against prosecution. We will never know until somebody tries to submit all this evidence in a trial. But defense lawyers will, I'm sure, object and say, you have to show us that that evidence was used that was gathered in this more neutral, balanced way. And so I think that's another dimension of this that remains unproven. I'm not sure they were doing that in 1945 and 46 in the UN War Crimes Commission. Fair enough, we have different standards today than they did at that time. But that too will have to be demonstrated. One final observation. I go back to this theme of the smaller countries and the big countries. It is fascinating to watch this. The UN War Crimes Commission was a body that was broadly based, and the smaller countries thrived in that atmosphere. They wanted to have a court that they would be a part of, where they would elect judges, where they would be part of designating the prosecutor, and they made a proposal along those lines until Anthony Eden came and said, we're not interested. And as we know, although we had this wonderful institution of the UN War Crimes Commission, when it came to organize the prosecutions for the Nuremberg trial, the smaller countries weren't invited. This was a private meeting held in London as well, by the United States, the United Kingdom, the Soviet Union, and France was then brought into this select club, the P4 of the P5, essentially. And the only reason China wasn't there was because these were European cases and European prosecutions. So what we see is this tension between the big countries and the small countries. We can see it in the UN War Crimes Commission. We can see it in all this, the smaller countries wanting to be part of it in a more democratic manner, in a more equal way, and the big countries wanting to run the show, if for no other reason that they also they understand the political dimension of these prosecutions, and they need to control them so that they can protect their own interests and those of their closest allies. And I'll conclude just by saying, tout ça change. Tout ça reste pareil. It's still the case today in international criminal justice. Thank you very much.
Thank you very much for that, Bill. Shall I let any one of our panelists begin with questions or comments? Dominica or Justice?
Maybe just refer to Professor Fabas's remarks. The whole context of Soviet Union's not being a part of UNWCC and Moscow Declaration is, as you said, topic for another lecture, but or conference. But of course, also this tension and this historical context that arises 1945 and later of the beginnings of the Cold War is also a very important aspect of the works of UNWCC, and also may be answer to the question why its significance or works. Significance or this influence on the development of post-war trials was lesser than could be expected. So political obstacles, on the one hand, is very important aspect to keep in mind, which also is related to the question of the Nuremberg trial itself, also not including the crimes committed by the Soviet Union and in general its omission after 1945 in this project of putting the perpetrators accountable for their international crimes committed during the Second World War. And this example of Central European countries or their political representatives, so countries targeted by, well, in this case, Poland was the only one targeted by both occupiers, but Estonia, Baltic countries were also affected by crimes committed by the Soviet Union. So, and again, this lacking recognition of this of victims and lacking legal responses after the Second World War is important point to mention here. I will start with this comment, so addressing also the Cold War context, which is a bit tricky when we look at the Polish case. So in summer 1945, the Polish government in exile, which was created by the democratic or Polish representatives from political scene from interwar period, lost its international recognition, and new communist government was created, which didn't mean that the whole work on documenting war crimes, classifying the evidence done during the Second World War was lost. And that's important to underline that some of these lawyers contributing to the UNWCC between 1943 and 1945 kept cooperating within this network until 1948, held their posts as UNWCC representatives delegated by the communist government, so their individual involvement, their professional knowledge, and was much more important than the political differences and the fears of coming back to Poland, to the communist country that was following a different model than this one supported and implemented by the government in exile. So the first post-war trials in Poland, especially of major war criminals, German criminals, were based on the principles developed by the UNWCC, also thanks to the persons, individuals who created the system before 1945 and then contributed to the works of the Polish Supreme National Tribunal. So this clear or simple explanation of Cold War reality and assumption of war crime trials and tribunals behind the Iron Curtain as maybe unfair, unjust, or following some Soviet model is not always or not that clear as simple as could be. But that's maybe some exception, but also important, as I mentioned, to add, and which also proves the importance of the works of UNWCC, of this network, community of lawyers and professionals having common goal and following some ideal in changing political circumstances after 1945.
Sure. Just followed on from Professor Seamus and Dominica's comments and presentation there. Yeah, I fully agree with you, Professor, about your point about we don't know that much about how the mechanisms do work, and I agree with your point about how I suppose it would be great to have a link between their mandate and I suppose a prosecution or a trial. I suppose by their nature and what they do, they are a lot of what they do is quite confidential, and even if you read their reports, their annual reports, there's only so much information that is included in those for a variety of reasons. And just following on from the point of Dominica and Professor Chavez about the role of how the UN War Crimes Commission really is an example of the progress that can be achieved when we move away from just the great powers focus on international justice and what that should look like. And by its nature, the commission was far more inclusive. And I suppose even if we compare to the 1990s with the creation of the Rome Statute in 1999 and how that was a multilateral massive conference with 120 plus parties or states that participated in it. Great things can be achieved when international justice is more inclusive. And for that reason, it is, I suppose, there's lessons there that we can learn from how the UN War Crimes Commission both was established and how it functioned in terms of the atypical power balance that we usually see within the international justice project. Thanks.
Yes, just maybe another thought about the composition of the UN War Crimes Commission. I think I was going to make this point when I got distracted by that background noise during my talk. But although it was broader and the governments in exile in Europe were participants and very enthusiastic participants and made very rich contributions, not everybody was invited. There was one country that requested on more than one occasion, and where questions were asked about why it hadn't been invited, and that's Ethiopia. This question arose in the British Parliament, where there were questions about it by sympathizers with the situation of the people of Ethiopia, friends of Ethiopia, who asked these parliamentary questions. And the British government had only the most feeble of explanations of why they weren't invited. And they were inconsistent with their policies as well. This had arisen in the discussions with the Soviets, actually, about Soviet participation in the UN War Crimes Commission. And the Soviets had said, well, it should be limited to countries that had been occupied or that had been victims themselves of Nazi atrocities. And that would probably have left out Australia and New Zealand and Canada. And so the British didn't really like that explanation, that theory about it. But the problem was that, and what they said in reply was, well, yes, but there were some of their soldiers who fought in Europe and they were taken prisoner. So they were victims of war crimes committed against prisoners. But that would have applied to Ethiopia as well. But they declined to admit Ethiopia. And at the very end of the work, in 1947 and early 48, they switched their position and they did finally recognize a couple of Ethiopians, a couple of Italians for having committed atrocities in Ethiopia during the 1930s. But it was ultimately, when you look at this and the pattern of the UN War Crimes Commission, it was inconsistent. And the British resistance to doing it was driven by, they were concerned about the investigations into atrocity crimes committed in Africa, because the Soviets weren't the only people who were concerned about responsibility for atrocity crimes, and the British and the French and the Americans all had this on their mind as well. So I think that's part of the explanation, and of course also just old garden variety racial discrimination, which would explain their indifference to the situation in Ethiopia as well.
We still have a few minutes for audience questions. Yes. Okay, let's please open the floor to the audience. Any questions?
Thanks for a great panel. Maybe just put the emphasis on today. If we think about the contemporary relevance, if we think about modern types of evidence, I mean, I understand Bill Chavez' criticism and under your criticism also of the investigative mechanisms. So what about digitally derived evidence? So would there be a gap? So if we think about what this model could mean today, what about these new technologies, this new digital form of evidence? This is where domestic courts struggle with. So could you contemplate some type of international mechanism which looks into authenticity, into verification, into some kind of common standard for assessing digitally derived evidence? Would that be maybe a novel function that could have a new role if we think about it from the contemporary perspective? Thank you.
Who would like to respond?
Thank you, Professor Stan. That's a really relevant question. I'm just gathering my thoughts on how to answer that. But I suppose going back to your point about common standards in the collection and the preservation and the and then use of digital evidence and then its use in national trials. I think what is required there is first of all the technology to be able to do that, and secondly training for national level law enforcement officials and judges as well. One of the things actually that does come within the framework of the EU genocide network. Now, obviously, that's a particular geographical area where that is relevant too. But it does provide training on law enforcement agencies and for judicial for judges as well. I don't know how that operates in reality, but it does come under its remit. But no, there definitely is, in the contemporary context, there definitely is a question to be raised about the gathering of digital evidence, how it's preserved, how it's authenticated. And I know Professor Yvonne Dermot Reeves with her university grant, I believe she's looking into the authenticity of a particular photographic evidence, because it's particularly relevant, especially if you look at the war in Syria and indeed in Ukraine. You know, the use of digital evidence is becoming more and more prevalent. We've got, you know, everybody has a mobile phone nowadays. They can take videos, they can take photographs. So evidence is more readily available. Then that raises questions in terms of, you know, whether or not fair trial standards are being met in terms of the collection and the authenticity and the verification of that data as well. But that is something that I don't know if we can learn from the Commission, from the UN War Crimes Commission in that context, especially given the lack of uniformity of standards between the various member states' trials. But it's definitely something that really should be more of a concern between national states. But that's just my initial thoughts on that. Thank you.
Carsten, I think it's in principle a good idea. I would be careful about how you formulate it, because there are probably forms of evidence that we haven't even imagined yet that will exist in 10 years or 20 years. When I started practicing criminal law many years ago, we had something called fingerprints. And that was about it, actually. DNA was had only been discovered, but people said, well, that's too expensive. You can't do DNA evidence. Of course, now it's everywhere. And so I'd just be afraid if you set up, you know, an institute to gather digital evidence in 15 years, they'll look back on the way we look back and say, we're going to have an institute to collect fingerprints on the battlefield or something. You know, it's just going to change. The evidence is going to keep evolving and changing. And the only thing that we don't know about is what we can't imagine will be the sorts of evidence 10 or 20 years from now. And the other thing is you want to make sure you keep some of the machines that we use to read digital evidence, because otherwise it'll be like those microfilms that we have in the libraries, and they don't have microfilm readers anymore to read them.
Maybe we should take maybe a couple of questions from the audience and then answer them. Anybody, please?
A very good afternoon. My name is Khalid Ahmed Chaudhry from International Human Rights Commission. Repeatedly, I heard Syria, Myanmar, then Putin. And we are talking about UN Commission on War Crimes. And my question to all of you is, if there will be ever a time that we will start talking about the war crimes committed by United States of America, our European allies, then Israel in Palestine, India in Kashmir. We are talking about Nuremberg trial again and again, but we aren't ready to discuss or at least to mention the ongoing war crimes. I thank you.
If there's another question, maybe we can take it at the same time and then answer both.
Hello, professors. My name is Christian Gonzalez. I'm a student on the Master's in Public International Law here at Leiden University. What I wanted to ask you is about what we learned from the United Nations Crime Commission and what can we do now? And nowadays, I was really reflecting on what Professor Chavez say about this double standard of gathering evidence, not only inculpatory evidence, but evidence that will lead to eventually to an acquittal. Do you believe that this is actually the standard that a new commission or the existing commission should take? And maybe to compose this a little bit according to what Professor Sam said, should also human rights standards be considered in terms of gathering evidence for this new commission or existing commission? Thank you.
I think we have just a few minutes, right? Okay, yes, so let us please answer both of those questions. First about the current work.
Well, yes, they should all be investigated. But I think I've said my view before when I talked about the failure of the United Nations War Crimes Commission to investigate the atrocities in Ethiopia. It's the same phenomenon.
I can only share Professor Chavez's view and underline the UNWCC, despite the success story we want to research and talk about today, the achievements of this institution, this inclusive model of cooperation that was elaborated and is for sure a very important example also for today, giving the voice to smaller or affected countries in designing the legal measures to resolve occurring problems and many other achievements which will be discussed today, but it is also history of failure or unachieved goals of permanent international criminal court, for instance, but also for more complex project towards accountability. Politics and law are not two separated spheres. They interfere, and UNWCC and today's debates mentioned here just showed very clearly. And unfortunately, this historical example or problem you can see on this historical example is not being solved. We should debate.
Thank you, and thanks very much for the two questions. Just to respond to the first question, I fundamentally agree with both what Dominica and Professor Shabas have said and what your point is. I think that international law reflects the powers, those who have power and those who don't. And as Dominica was saying, law and politics are, they're not separate, they're very much intertwined. I would hope that, considering that international criminal law is in its infancy, that in the future things will change, especially with, even within the discipline of international law, there seems to be in the scholarship, which is what I'm more familiar with, there is a big push from third world approaches to international law to critique the system, or try and identify through history, using history to show how the rules are formed to benefit those with power rather than those without. And even if we look to the power struggles within the UN War Crimes Commission itself, where you had the likes of Egon Schwell, Stefan Glasser, and others who were asserting that the War Crimes Commission should expand its remit in terms of advocating the prosecution of crimes against humanity, and obviously the powers that be, primarily the US and the UK, had big problems with that because they were afraid that it would lead them, they would themselves be liable for the treatment of minorities in their respective territories. So that is a prime example of how we looked at the history of international criminal law. It does protect those who, or certain entities that inflict violence when they have power, and that's unfortunately the reality. But I do hope that things will change, and perhaps we can look to the archives of the UN War Crimes Commission for that customary international law to be able to advocate more for a fairer and more balanced approach to the application of international criminal law. Thank you.
I think our time is up. Thank you, everybody, and thank you for the questions. And thanks for
from this very important panel. My name is Deborah Rizvandusco. I am honored to be the Executive Director of the Trust for Victims since a bit less than 6 months. So I'm very much new to many of you, although I hope the Trust for Victims itself is not, even if we are in a current effort to enhance its visibility. And therefore, I really thank the Embassy of Poland, the University of Leiden for inviting me to moderate this important panel, because ultimately what we're doing at the Trust for Victims at the ICC is the culmination of all the history that is upon us that results in understanding how crimes against vulnerable populations, how crimes impact victims, and what is the role of the international community in redressing that harm against victims. So this panel is seeking to give the other dimension, right? How do we document, how do we investigate and successfully prosecute those crimes? What are the institutions that we have at our disposal? But then what is the affectation of the victims themselves? How the investigations or the trials redress the harm done on them, and also what is left to be done to ensure proper justice that should be composed from this access to justice, effective investigations, as well as reparations. So it is really an honor to also learn from our panelists. I will jump right straight to them so that you can hear more about them and less about me. And I'm going to start with Wolfgang Form, who is the Managing Director of the International Research Center for War Crimes in the University of Marburg. And he's now working at the Free University of Berlin. And he will be speaking about the history of the Commission, and looking also in particular at vulnerable populations, children, and also the perspective of also sexual violence. I'll jump straight at you, and thank you for me.
Thank you so much, Laura. You hear me okay? It's okay? So wonderful. I should go a little bit further in history than 1943. Depends on, it's important to understand, let me see, the long dynamics of international criminal law, especially in question of war crimes and crimes against humanity. But first, Bill, I was thinking about Ethiopia and also the Soviet Union. And maybe it has to do with the Soviet Union that they early began with war crime trials before the UNWCC was established. And second, they already have had a law, the UCAS 43. And maybe that was also an idea why they didn't jump in the boat in London. Depends on if they did that. Some others can say, you must correct that or this. That was an idea of some Soviet or Russian historians, what they told me. Maybe it's wrong, maybe not, but it's an idea. But the question is why they did that in 1943. Did they wake up in the morning and say, okay, it's nice to have a new international community and a national conference? No, the point was a total different ones. It started actually with the World War II, World War I. I call that the 4N and the 1F. No international body in the First World War, no discussion in the time about what we will do with the German perpetrators if the First World War is won. The third, they have had no plan in the time what they want to do. And the fourth was, there was no common institution. And the 1F is, that was what they did after World War I, was at the least a farce. It doesn't work. How we call that today, transitional justice was nothing than nothing. Let me see it in this way. Okay, what did the United Nations War Crimes Commission in the first stage? I start with the end. What they did is a very impressive index. More than 1,200 entries you find in this index. But what you don't find, or only on a little stage, is something what's happened with women, with rape, with forced prostitution, and on the other hand, with children. It's not in the index. Let me see it in this way. This index, this outcome of that, what the United Nations War Crimes Commission did, it was a child of the time. They haven't had that in the forehand, they have had that in their back mind. It depends on, in 1919, and I go back to the First World War, they have had a list of 23 war crime complexes. And on the fifth and on the sixth stage, it was rape and forced prostitution. That means it was not an alphabetic list, it was a methodic one that was in their mind. But let me see the chain between that, what they really want to do and what they theoretically have had in their mind. It wasn't come together, also not in the Second World War. But if you go in the papers, you really find a lot of information about what was happened with women, what was happened with children. And I will give you only a few examples what you find in the papers themselves. The papers, what I mean, are the papers, what they change under each other. More than 1,800 documents are still in archives, not always all on one places, what describe what they circulated under each other. That was what they all know, definitely. Depends on they have that on the written page. First was that the bear, we saw them, I think, on the picture. He stated in July 1948, 43, it is characterized that neither the British manual or Oppenheim-Lauterbach Kommentar have included rape along the violation of laws of war, for it has absolutely nothing to do with the war. That was what they have had in their mind. So that was a picture out of the time. It was nothing that what we have at present. That's what I mean with the long waves of dynamics, what things are changing. It's like that, what atrocities were told us today. What we have now today as atrocities, I have no idea what we have in 50 years. And what they have had 80 years before. It was also a total different understanding, but maybe what we have had today. However, we have mostly references against on atrocities against women, on women as slave workers. That was in what was happening in concentration camps and in other camps, or what was happening by the time where they catch the slave workers in their home states. But in my perspective, more interesting in the discussion for the day is what they were talking about children in the documents of the United Nations War Crimes Commission. That was very interesting that they focused on one very interesting topic, recovering children of so-called good of ethnic types into the German so-called race body. That was a point what they want to do. That means underneath races, they could have some important genies or important genes. That's what they have had in their mind, to include them in the German society. And if they don't need them, then I citate, they are going to destroy it. It are the children of slave labor. And then we found also hits about how the Germans did that. And one of the topics is they brought pregnant women into special camps. And the babies were killed, stayed ahead or after the next 3 months. It's interesting that only one of the Allies brought such cases before court, the British, the so-called baby home cases. Not in the French zone, not in this American zone of control, and so far I know that correctly, also not in the Soviet zone of control. That means this very important part, what we find today, and I think that is the ball for Oksana later on, that is exactly that what you find more or less in the war of aggression between Russia and Ukraine. Take people out of the other bodies, families, regions, and bring them back or bring them to be a new Russian child or children. So, and exactly that was the idea what the German Nazis has had and what we find in the papers of the United Nations War Crimes Commission. That means that is not a common topic. That is something what they have had 80 years before. And that was what the Nazis did. Very interesting is that Lemkin put out this fact in 1946 in a very impressive memo. Citation, the stealing of children from occupied countries is a part of the great plan of destroying the demoscopic structure of the neighbors of Germany want to destroy. And that he called genocide, 1946. We can discuss if that what the date is in the same manner. I jump to crimes against humanity. Of course, it is a big gap, but it has really to do with each other. Depends on why they need a new crime. But what crimes they were well known? Crime of aggression, okay. Genocide wasn't in the discussion so far, depends on that was something, it comes later. But why crimes against humanity? What was the reason for that? We must have in their mind that they have a dilemma. The dilemma was the prosecution of Jews. If this part of the audience are German Jews, and this, the greater part, are non-German Jews, they were prosecuted by the German Nazis on the same intent. They want to destroy Jews. Doesn't matter if they are Germans or the non-Germans. But in the perspective of the law at this time, the dilemma was that the perpetrator could be brought before court as a war criminal. This side, if the victims were Germans. It was impossible. Depends on a war crime. At this time, you only can do that against an enemy. For the other ones, no problem. That means they need a second crime that they can also include the prosecution of the Jews. Depends on, it was clear it was 1 in 10. They couldn't exclude that. There were some ideas to do that, especially by the British, more by the United States. They said, there's interior stuff, what they did with their own population, this has nothing to do with us, but really good idea. That is impossible, depends on the intent is the same. So in this perspective, they went, and you find that very clearly in the documents of the United Nations War Crimes Commission. First, they were thinking about, we must expand war crimes so that destroying a whole population is per se a war crime. But law theories say it doesn't work. Depends on this war crime thing, could be only work first in wartime, and second, only against enemies. Then they said, okay, then they label that crimes others than war crimes. You see? But then they said, yeah, what should that do? You cannot say war crimes and say other crimes than war crimes. And it's okay, we see what was happened. Crimes for reason of race, nationality, religion, and political creeds. Systematically planned and carried out. That was the third step. And from this description, it was a very, very short way to describe that as crimes against humanity. In this time, in the Nuremberg Charter from 1945, something what only did in wartime. That was the idea at this time, that things what was happening, atrocities that were happening before the war, they were in the Nuremberg Charter excluded. But only 4 months later, in the so-called Control Council Law number 10, they included that. They opened this border and said, this doesn't matter at which time. It is a crimes against humanity if you prosecute out of race, nationalities, religion, and not political creeds. I mean, then ethnic backgrounds. And last but not least, that was what we today have as crimes against humanity on civil population. And my time is so fast.
Not yet.
Not yet. Oh, 1 2 minutes. I thought about 2 minutes over. So interesting is that what the colleagues mentioned before, that questions of crimes against humanity were not included in the first draft of the International Criminal Court in 1944. But let me see them this way. They had an opener in it. I will make a citation. The first draft for the creation of international criminal law in February 1944 was as a memo by the United Nations War Crimes Commission. There was no crimes against humanity expressis verbis mentioned. Only war crimes or crimes in wartime violating the general principles of law as recognized by civilized nations and done in wartime. I think that is the opener. That could be also a path in the direction crimes against humanity. Depends on, they say clearly, recognize atrocity against the law of the civilized nations. And I think that is the starting point of that, what we mentioned today. And if you see in the ICC statute at the paragraph crimes against humanity, you will see that most of that what I'm cited, it's included. Of course, a lot of more, and that are the long waves, the long dynamics. That's what's different between the end of the World War II and the work what the United Nations War Crimes Commission did, and that what they did in 1998 in Rome. So in this perspective, I'm very happy that there is such a such a dynamic in that what we today call international criminal law. Thank you so much.
Indeed, in the Second World War, you have 2 million children evacuated, and as in any war, rationing, the impact of not being able to go to school, the separation from their families. 1 in 10 deaths, for example, in the Second World War were children. And it's unavoidable to have an impact on the most vulnerable population, that is children. And the Rome Statute came a long way in actually innovating, not only in looking at the impact of conflict or the war crimes on children, but also in identifying specific crimes that against children become war crimes. And the biggest innovation, as you know, is the use of children in our forces, the recruitment or their conscription. And the cases that the Trust for Victims is now working on, the reparations, are concerned precisely with those former child soldiers and the harm that was done on them. So a long way historically has come from that moment of the recognition of children to what the International Criminal Court is working on now. The Office of the Prosecutor at the ICC has also issued special policies concerning how to address, in particular, children and in their investigations, not only the impact that the crimes that they are investigating has on children, but specific crimes against children. And this culminates very much visibly in the 2 recent arrest warrants in the situation of Ukraine. And that have a context, a very important context, that now Professor Oksana Senatorova will be talking about. You are director of the Research Center of Transitional Justice at the Yaroslav Mudryny National Law University in Kharkiv, and you will be talking about, in particular, about the Ukrainian situation.
Thank you very much. Your Excellencies, distinguished colleagues and dear friends, it's my special pleasure to be here today and to present on this topic. First of all, I would like to make a disclaimer that the views expressed in this session are my own and do not reflect the position of any organization or institution that I collaborate with, because I'm the expert to several international organizations and institutions. And I will speak about the deportation of Ukrainian children, and will pay attention to the contemporary situation in this regard. Thank you, Wolfgang, for pointing out, for highlighting this like stealing of children during the Second World War. And indeed, United Nations Law Crime Commission suggested to criminalize, and the deportation was criminalized after the Second World War, though it was suggested even before, after the First World War. But nevertheless, even now in the 21st century, we continue facing this crime committee with the huge widespread effect. I would also like to flag the legal regime which we are talking about and qualify the armed conflict existing in Ukraine. There is no internal or non-international armed conflict, so-called Donbass conflict in Ukraine. The armed conflict in Ukraine is international, and it started with the invasion of Russian forces to Crimea, continued with the proxy occupation and invasion as well of Russian forces to Donetsk and Lugansk regions of Ukraine. And the third phase of this conflict started on 24th of February last year with the full-fledged invasion of Russian forces to Ukraine. Since 2014, since the very beginning of this armed conflict, Russian army continued, started this deportation of Ukrainian children, for example, from Snizhne. It's the town, small town in Donetsk region, but At that moment, the Children Ombudsman of Russia, Starhov, immediately returned those children after Ukraine announced about this deportation. Now we see quite opposite, no returning of Ukrainian children. And since February 2022, Russia has deliberately created coercive conditions in which civilians in temporary occupied territories have had no choice but to go through Russia or to go or were evacuated, as Russians called it, were deported, in fact, to Russian territory. I mean, the creation of humanitarian crisis in the captured cities, such as Mariupol bombing, food storages, starvation, resulting in starvation, bombing residential areas, water and electricity stations, blocking Ukrainian green corridors, forcing local population to flee to Russia, direct shelling of Ukrainians trying to escape from the occupied territories. They were told that the whole territory of Ukraine is occupied now, so you have to go to Russia if you would like to survive. These coercive conditions are the elements, are the indicators of forced deportation, because forced doesn't mean, doesn't have this narrow meaning. Here we see some examples. You see the Mariupol area. This is Izum in Kharkiv region. No hostilities in the center of the city. It's the result of bombing. Some sellings in Kharkiv region as well for sellers, torture sellers. And here you see civilian cars trying to escape from Russian occupation. 10 children were killed. The Kharkiv region as well. Kharkiv region as well. Lots of civilians. 440 graves were found after the occupation. These are the photos illustrating those coercive conditions. Let me provide you with the numbers of deported civilians and deported children as well. As for the numbers, the UNHCR stated that it was 2.8 million of Ukrainians who crossed the border. Of course, not all of them were deported, but you can imagine the numbers as well. As for the children, it is more than 500,000, or even according to Russian forces, according to Russian official data, it's more than 700,000. As for Ukrainian recorded information, it is 19,500. It is information according to the relatives and to the parents. You know that there are several reports, Ukrainian reports, international reports, OSCE, Moscow Mechanism, third report, the United Nations Inquiry Commission report as well, where you can find information about this deportation. What are the patterns of this deportation? Children have gone missing during the hostilities, the active hostilities and shelling in the cities. There were large-scale deportation of orphans, transferring children with consent of parents to occupied territories for so-called rehabilitation, and after that, these children ended without consent of their parents in the territories of Russia. Killing of parents and taking their children as well, deprivation of parents' rights within the occupied territories. This deportation was planned, and the whole government apparatus of Russian Federation was involved. First of all, on the 30th of May, the special legal act was enacted, according to which Ukrainian children received Russian passports, so-called passportization. This passportization allowed the adoption of those children, because if they are foreigners, they could be adopted, and they were adopted in foster families, and according to Russian law, their names can be changed, the date of birth can be changed, and it was done already, eliminating all the traces to Ukrainian origin of those children. So you see, this orchestrated, this whole deportation was orchestrated by the Russian authorities, and you see the chain of command from the president, the ombudsman, the children ombudsman. Actually, Maria Lvova-Belova, the children ombudsman of Russia, she gave lots of interviews showing this aim of Vladimir Putin and her own aim to change the identity of Ukrainian children, because they were not allowed to speak Ukrainian, to sing Ukrainian anthem. It was prohibited. They were pushed to sing Russian anthem, and they were put in camps, special camps, where they were re-educated, so-called, and of course lots of other things in those camps or in schools. Some minutes of hate, we can say, these lessons of patriotism, and so on. And Maria Lvova-Belova actually explained everything in this regard. You see lots of photos, interviews, etc. As for the local sites, local media, you can find it if you speak Russian or read in Russian. You can find some information like announcement. Please come and pick up Ukrainian children. They just arrived. You can choose anyone you want, just like pets. It's local media in Russian Federation. As for changing of identity and militarization, you see, this is the children's organization in Russia, so-called UNARMIA, something like Hitler Jugend. And they militarize children officially, even in kindergartens, you see. And here Maria Lvova-Belova, during these lessons of patriotism in Russian Federation, where the whole campaign of changing Ukrainian identity, you can see it. As for the legal prohibition of deportation, I'm sure I don't have this ambition to cover all the elements of legal qualification of deportation as war crime or crime against humanity or genocide. My aim was to show you the facts actually which are going on in Ukraine now. But there were no reason to evacuate even some Ukrainian population from the territory, because during the invasion, so-called functional occupation of before the establishing of control, of effective control, immediately during the first days, children were forcibly transferred to Russian Federation without any reason to do it. There is an obligation to return and provide access of international organizations. No access to any international organization, no obligation, no returning. I can say that after the issuance of arrest warrants by the ICC, some returning processes already started, and Maria Lvova-Belova proclaimed that some children have been returned to Ukraine. So we see the efficiency of those arrest warrants, I can say. As for domestic prosecution in Ukraine, we have more than 90 cases, 90 criminal proceedings on deportation as war crime as well. And we also have another avenue, it's domestic jurisdiction on the basis of universal jurisdiction. And as to my knowledge, in Germany, they already started some prosecution of war crimes, but not, I don't know whether it was deportation. And current national steps, I announced that transitional justice framework is important. As well, I can say that in Ukraine, the Unified Register of Deported Persons was created, and the register of the victims of armed conflict, of survivors of armed conflict, or the aggression, because it could be different so-called victims of IHL violations and serious violations of human rights, victims of armed conflict and victims of the crime of aggression. And of course, we pursue the aim to defend all of them. And transitional justice, a framework in Ukraine, was aimed to be victim-centered. And currently, we need to define what does it mean, what the victim means, to create the national mechanism of reparations, national reparational mechanism to all the victims of this crime. And of course, we need to create the special measures to return the deported children. And in this regard, if I can say that we need to lower expectations concerning the criminal prosecution in international jurisdiction and in national jurisdictions, because it is unbelievable that more than 100,000 criminal prosecutions started in Ukraine could be brought to trial. We need to look at this realistically, but I don't want to lower hands as for the returning of deported children. It is like the first aid. We need to do it until we see the results. And in this regard, we need assistance from international organizations, partner countries who will push Russia to return Ukrainian children, who will take these children coming from Russia to this real democratic environment where they will be not re-educated, but will feel this freedom. And I'm sure that in Ukraine or in other countries, inviting them, they can feel it, this freedom, and we will recover them from this situation they faced. I'm sorry, this 15 minutes is not enough, so I'm open to your questions on genocide, on crimes against humanity, and war crimes qualification. Thank you very much.
Thank you very much, Professor Senatorova. And indeed, just a commentary on this point, being a situation under jurisdiction of the court, as well as other 30 situations under jurisdiction of the court, the Trust Fund for Victims is able to initiate programs of support to victims. And it's at the moment under the instructions of the board of directors in the situation of Ukraine, as well as in other situations where we're not currently active, exploring the ways in which our efforts could be contribute to the other ongoing efforts that are being undertaken. It feels a bit of a bridge now to something that is really material, going from the individual victims, the humans that suffer as vulnerable populations, but actually there is a very important human element to the next topic that will be addressed by Professor Powderly, and which is the cultural heritage. And he's specialized on this issue and will be speaking about the attacks against cultural property from the historical perspective and the contemporary practice, where we also can see jurisprudence and ongoing efforts in this respect. So Joe, please.
And thank you, Deborah. Your Excellency, Mr. President, esteemed colleagues, both present in the room and joining us online. It's really an honor to be joining to discuss this really important institution and its historical legacy. I want to talk about the UNWCC and crimes against cultural heritage. And actually, I think my remarks dovetail very nicely with those of both Oksana and Wolfgang, because in discussing the issue of the forcible transfer of children, we are fundamentally talking about sort of an elephant in the room, which is the issue of genocide and the forcible transfer of children from one group into the group of another, the only remnant of Raphael Lemkin's conception of cultural genocide to make its way into the 1948 Convention. So that is definitely in the back of our minds as we discuss these issues, and the facts as laid out by Oksana are deeply troubling. I've come to this subject particularly because of my interest generally in crimes against cultural heritage in the context of armed conflict. And it's been something of a fashionable topic in recent years. It's been highlighted in a number of really important seminal cases, not least the Al-Mahdi judgment from the ICC, which is an important case. And for those of us who were involved in cultural heritage destruction, the guilty plea was both a blessing and a bit of a disappointment, because we were hoping that this case, which focused exclusively on crimes against cultural heritage, would really unravel some of the perceived difficulties of the issue under the Rome Statute. But alas, we didn't get there, but we did get some interesting jurisprudence on reparations, on guilty plea, and what have you. But in the context of this moment in which the Office of the Prosecutor appears to be highlighting heritage destruction, has published a policy paper specifically indicating his office's position on cultural heritage destruction and placing it as a central pillar within its investigative strategies. I wanted to look and see, well, what has the UNWCC actually done? What legacy is there for the UNWCC? Given the work that Dan and others have done, it's something which I think there were kernels of historical narrative without the full story having been told. Now, in his book, The Faustian Bargain, The Art World in Nazi Germany, Jonathan Petropoulos made the argument that only tyrannies understand the power of art. And I would say we should expand that and say only tyrannies understand the power of heritage, because heritage goes to the heart of our identity, both individually and collectively as societies, whether we look at that on a national level, a regional level, or an international level. Heritage is goes to our shared humanity to a degree, and we see that reflected in cultural heritage treaties, be it the World Heritage Convention or the Convention on Intangible Cultural Heritage. And we are all affected in one way or another by the destruction of cultural heritage. This is an issue which has been reflected in the Al-Mahdi case, and particularly in the reparations judgment, which recognize the different layers of harm that arise from it. So you would think that given the centrality of heritage destruction to atrocity crimes, you would expect there to be a long history of prosecution or investigation thereof. But in the histories of prosecution of heritage destruction, we tend to focus on the legacy of the ICTY in this respect. It made great strides, it linked and made clear the connection between heritage destruction and discriminatory policies of persecution, the relevance of heritage destruction to establish a genocidal intent. But if we go back before the ad hoc, so we go to Nuremberg, we find we have the Rosenberg judgment, Albert Rosenberg being the overseer of the profoundly astonishing Nazi policy with regard to the looting of cultural heritage. But I was wondering, is there something before that? Has the UNWCC done anything? Okay, in this respect. So I went through the archives and I've been digging about and I've been finding bits and pieces, and I want to talk to you a little bit about what has been done. It is, in many respects, an issue which leaves one slightly dissatisfied with what exactly the focus of the UNWCC was in this regard. Okay, because the dimensions of Nazi looting and destruction on cultural heritage was vast. It's very difficult to do justice to it in a few short remarks. We know that looting was sort of linked to issues of personal greed, okay, particularly amongst those in the high command. Frequently Hitler and Göring would fight over particular works of art to have in their own personal collections. If it was for Hitler, he wanted it for his Führer Museum, which he had Albert Speer and others designed to be based in Linz, his hometown. Göring had his beloved Karen Hall estate, which he filled with priceless works that he had looted from all over Europe. He had Cranachs, he had Holbeins, he worked from Van Gogh, Monet, Botticelli, Rubens. And on Rubens, he even used this wonderful Diana at the Hunt to basically cover his projector when he wasn't using it. Okay, so we had this extraordinary situation of vast accumulations of personal art. Just to link it back to Poland, Hans Frank, the former Governor General of occupied Poland, when he was detained by the Allied forces, he was found in his possession to have Da Vinci's Lady with an Ermine, wanting to hold on to it, thinking he could keep it for after the war. But what of the connection between the UNWCC and cultural heritage? Well, when we look through the archives, we see that there is some connection between the UNWCC and other bodies who were engaged in collecting evidence of heritage destruction. In this regard, I'm going to mention the so-called and highly gendered monuments. Okay, here you have a picture of the 2014 film directed and starring George Clooney. It is an abomination from a historical perspective. It's not great from a purely point of entertainment. I would not recommend it. I would give it 15–20% on Rotten Tomatoes. But it does tell the story of the Monuments, Fine Arts and Archives program, which had been set up by the Allies. Now, the primary concern of the MFANA, as I will call it, I won't refer to it as the Monuments Men, because in fact there were very many women who were involved in its activities as archaeologists, anthropologists and others engaged in their primary work, which was the safeguarding of cultural monuments at various sites of historical significance and the restitution of cultural objects which had been looted. And there's plenty of evidence to suggest that there is a connection between the MFANA and the UNWCC, that they were cooperating. Okay, and this goes to some of the remarks by Dr. Adnan earlier on about the various networks that we see of cooperation. For the UNWCC, it definitely set a model, okay, but when it comes to heritage destruction, this is all we're seeing is the MFANA and the UNWCC. And when we look through the archive, we see different documents to suggest the nature of this cooperation. So if we look at this document from July 1945, it's Summary of Information 35, and it's titled Looting by High German Officials. And we see significant portions of this report are derived from the Monuments and Fine Arts branch, the MFANA. We also see that it refers to basically interrogation reports that the MFANA had carried out. And if we go further into the archive, we will see that certain individuals are highlighted in these investigations. One figure that I pulled out was a Professor Alexander Langsdorff, okay, who was a art historian, and the MFANA report identifies him as having played a really important role in the looting of Italian works of art on the instructions of Hitler and Göring. It also includes summary accounts of his own statements that he made to the MFANA, where he said that he should be considered a bit like Albert Speer. Okay, it's namely someone who tried to lessen as much as possible the harm that was likely to result from the looting of cultural objects. Now, later on in this document, the MFANA recommend that, or hope at least, that the UNWCC will do something about Langsdorff, will actually add him to the list of wanted individuals, and they might be able to do something about it. And we see this reflected in another document where we have this plea, please do something with regard to Langsdorff. And the documents were sent to the Italian government in the hope that they would put together a set of charges and take the case forward. Unfortunately, Langsdorff died of a pulmonary embolism in 1946, and the case went nowhere. Okay, so we have the MFANA cooperating. What other bodies did we have? Well, one other is a very interesting one, which is the Inter-Allied Commission on the Protection and Restitution of Cultural Material. This was also known as the Voucher Commission, named after its chairman, Paul Voucher, who was the cultural attaché to the French embassy in London at the time. And this body was established by the Conference of Allied Ministers of Education, so the precursor to UNESCO. Set this up in April 1944. It later went on to be chaired by André Gross. Okay, and there we have a direct sort of overlap between the UNWCC and the Voucher Commission, because Gross is one of the founding experts on the UNWCC. He was involved in the drafting of the London Charter. He then went on to serve on the bench at the ICJ for many years. The mandate of the Voucher Commission was to collect information, okay, to collect evidence, not only of looted materials, but where they've been looted from, where they might have been trafficked to, who was responsible for them, to put together lists of suspects and how they might be pursued. Okay, so obviously you can understand why the work of the Voucher Commission would be of interest to the UNWCC. But it wasn't until 1945 that we actually get a formal meeting between the Voucher Commission and the UNWCC. And this goes to the fact that heritage destruction and collecting evidence relating to it was something of an afterthought when it came to the UNWCC. It was not foremost in their sort of investigative priorities, presumably because these were crimes against property or viewed as crimes against objects, okay? Sort of not realizing or appreciating that the connection these objects have, these tangible objects have to intangible forms of cultural heritage and forms of identity. So it's very much quite a literal understanding that we pursue crimes against persons, not crimes against objects. But in March 45, we have this meeting between the UNWCC and the Voucher Commission. And the idea is that under the leadership of Cecil Birch, the UNWCC wants to widen the scope of its activities and take into account crimes against artistic property. So from this meeting, we then have some additional sort of concerns which go to the cooperation issues which we still deal with today. The Voucher Commission wanted to work with the UNWCC, but it wanted to retain control. Okay, so you still had this back and forth, this, you know, this trading of power and position, which I still believe is a very difficult issue to overcome when you have multiple bodies dealing with a particular situation of armed conflict. So the commission, the Voucher Commission wanted to have some control. They were denied it. UNWCC said, we'll take whatever files you have. They roughly looked at 800 files that they had from the Voucher Commission, and then whittled that down to 40, and eventually chose 4 cases that they were going to look at and forward for prosecution. But the Voucher Commission were very interested. They said, fantastic, please keep us updated on what's happening, but they never were informed. And I have yet to discover exactly what those 4 cases were. I'm still looking in the archive, I haven't found it. We don't know what those 4 cases were, what they dealt with, but they were deemed by the UNWCC to have been chosen because they were representative of the types of crimes that were being committed relating to artistic property. So I'm still digging around for the full history of the UNWCC's legacy on cultural heritage. We do have some further indications from the law reports of the war criminals. We know that there are various cases relating to this that are reported. The trial of Karl Lingenfelder, who was prosecuted for destruction of monuments, Franz Holstein and Hans Verledos, pillage and destruction of protected buildings, Willy Zulk, who was also prosecuted, interesting, for denying access to spiritual guidance. There's also the case of Otto Greiser, okay, and it's important in the context of an event organized by the Polish government that we mention this case, because it is perhaps the most significant case prior to the ICTY dealing with destruction of cultural heritage and its connection with other crimes. It also baffles me why the Greiser case is not further discussed. It deals with issues of denationalization, forced nationalization, and looting and destruction of cultural monuments. So the lesson that we can, and I'm going to conclude, Deborah, the lesson that we can conclude from this rapid run through of the UNWCC is that cooperation can lead to some progress, but there are major stumbling blocks along the way. We know that in the context of Ukraine, UNESCO is documenting heritage under threat and heritage that has been destroyed. You will see a monthly update on the UNESCO website. the Ministry of Culture and Information Policy is also keeping its own tally. We have the International Council of Museums, which has a red list on cultural objects that have been looted and are in the art market currently. We know that this has happened in Kharkiv, we know that it's happened in Melitopol, we know that cultural sites have been destroyed quite infamously. We know the case of the monument of Badian Yar and various other sites of important cultural significance throughout Ukraine that have been targeted on the face of it intentionally. What we need is further attention and cooperation and collaboration on collecting evidence relating to these crimes. There was a report published just last week by the International Blue Shield. It was a report commissioned by the European Union. And its president said that no country is doing enough when it comes to the collection of evidence relating to the destruction of cultural property. It's being documented. We know the sites that are being destroyed. We have satellite imagery, but we do not have evidence that can actually be used to prosecute these crimes, primarily because we don't have access, or at least resources are not being channeled towards those types of crimes because of the prevailing view that these are crimes against property, not necessarily people. But I would argue that that is somewhat small-minded when it comes to the significance of heritage destruction on identity individually, collectively, and so on. So sorry for running over the
Thank you, Joe, Professor Connolly, Associate Professor here at Leiden University, at the Grotius Center. On that point, to complete the image of the importance of cultural property and its destruction, the case of the ICC is being the reparations program that has a value of more than 2 million euros, which is funded primarily by the Canadian and the German government, as well as contributions of many other states parties who are present in the room and to which we are very grateful, has a very comprehensive component. There was an apology, also a recognition to the state of Mali, who suffered the loss. There has been compensation to the individuals that died in the attack or the human remains that were destroyed from the destruction of the mausoleum in Timbuktu. There is also work with UNESCO to restore the buildings, the mausolea themselves, and there is work with the communities to restore the history of the mausolea transmitted to the children, and also repair the economic impact that the destruction of the mausolea of Timbuktu has on the communities. So this is to echo that point of, yes, it is material, but it's not private property. This is a humanities property. And taking advantage of Josh Hoffmanski is here, and he was in the appeals chamber that affirmed the reparations award in the Almaty case. I do want to quote not the appeals chamber, but the trial chamber, who said that the destruction of property, and I would add here also the attacks against children, send a message of terror, helplessness, destroy humanity's shared memory and collective consciousness, and hinder our capacity to transmit values and knowledge. And this is something that we see now history upon us, with a big call for that cooperation that you're mentioning, to document, to prosecute, but also to restore the harm done on the victims. With this in mind, I hope that the amazing panel has piqued your brains. Thank you so much for the very important historical research that is being undertaken, and to the organizers for bringing that up to the public, and hopefully this can be used to continue our knowledge, our transfer of that consciousness that the institutions that we are working for or working with are striving to achieve. So I would like to open, I don't know, Carsten, how much time do we have for audience?
10 minutes or so.
5 minutes, very good. So people comply with that. Please do introduce yourselves when posing your question, and try to keep it brief. I know that many of you have a lot of knowledge, but to keep going the conversation, just try to, let's pick these brains as much as possible. So please, sir. Is there a microphone?
Yeah, so maybe I will start because I have a question too.
Another coup d'etat. Very good.
So I have a question.
What is your name?
I'm Alexandra Konopka. I'm from Pulaski Institute.
Yeah.
And I have a
question to Dr. Senatorova and Dr. Ford. Could you try to examine the effectiveness of the international standards for preventing and enforcing state and individual accountability for illegal deportations and forced relocations of our children? And actually, should we focus on outlawing or criminalizing deportation and forced displacement? Which way can be more effective for the crimes that have been committed on the children? And last but not least, is there any way that Putin or Lvova Belova can be ever judged? Thank you.
Okay, we'll take a few questions. So we'll get to start here, please, because he raised his hand first. Thank you.
Would you like to?
Good evening. Good evening, everybody. My name is Glyn Morgan. I'm the lead investigator with the Atrocity Crimes Advisory Group in Ukraine. I've been there since June of last year, and a recurring problem that we come across is a focus on investigating and prosecuting low-level direct perpetrators, usually prisoners of war, at the expense of building cases against higher-level indirect perpetrators in the chain of command. Part of the reason for this, I think, is a lack of knowledge or confidence about the possibilities that are present in the Ukrainian criminal code, although that is perhaps not perfect in this regard. And therefore, there's an unwillingness to pursue those kind of cases. But in the context of what the panel has talked about this afternoon, it's highly unlikely that Russian soldiers would have collectively loaded Ukrainian children onto buses and transported them off to Russia, or that Ukrainian soldiers would have taken works of art out of art galleries in Kharkiv, for example, and loaded them onto trucks. And the whole way in which that was organized clearly implies that there is some higher level of command and control behind it. So specifically for Oksana, whether there is, in your opinion, possibilities in the Ukrainian penal code to hold commanders responsible in the absence of evidence of direct orders that they have given, and perhaps a broader question relating to the work of the UN War Crimes Commission, who must have been faced with similar problems, where you've got lots of different countries who are being asked to bring cases where perhaps their national law may not include or may not have all the possibilities that might be available under international law or customary law, and how the Commission was able to create that broader and balanced and ambitious approach such that indirect perpetrators would be held accountable.
Thank you. We'll take a third one on that side of the room. The gentleman there in the back, please. Thank you.
Thank you very much. My name is Eugene Kanyugo. I'm a student at the Advanced Academic in Public International Law. Now, my question is to Dr. Powderly, and I think that it's an A and B kind of question. And I'm one of those people who also are very disappointed with the guilty plea in the Martin case. And my question is coming out of there because there's one statement that Martin said during the conflict, which was that he quoted, he was talking about a shrine, and he said, those UNESCO jackasses, I'm sorry to say this, they think this is heritage. And unfortunately, I mean, it's an unfortunate statement, but you see a possibility where the ICC or criminal courts could also come up with a standard which is a bit lower than the UNESCO standard of achieving heritage. And the second connected question to this is it possible, again, for us to have in the criminal jurisdiction, us to have a new perception of victim that includes culture, that includes property, because, for example, the crime in H2E4 is a crime against property, but the standard is still that of number of casualties. Yeah, thank you.
Okay, because we're not gonna have any more, another round, we're really short on time. We're gonna take one more question from this gentleman, and then we'll go to the panel, and that would be it. I'm very sorry.
Hi, thank you. My name is Shanti Bhatt. I'm a recent graduate of the Masters in Political Science program here. My question is kind of going off the similar framework of like holding individuals accountable for destruction of cultural property. Are there any other lessons within the commission for potential crimes on the concept of ecocide, even though it wasn't established then, but any lessons for applying that into situations like Ukraine and
Great, thank you so much. So that was 5 minutes of questions, and then we'll have 5 minutes of answers. I'll give it, maybe first to Professor Paroni.
Okay.
Would you want that? Yeah.
Sure. Thank you for the great questions. I'll deal with the one that was directed at me specifically. Yeah, UNESCO and what we designate as heritage, it's extremely problematic in international law generally, but in international criminal law context specifically. Because if we look at the ICTY legacy, you see that sites which carry the label of a UNESCO World Heritage Site are viewed as being in some way of more significance than non-listed heritage sites. And the way in which a particular site or landscape or city or whatever it might be is added to the UNESCO World Heritage List is profoundly political. And I would recommend the work of Lynn Meskel, who has written extensively on the problematic way in which UNESCO operates in this regard. And what is really important, I think, is that international criminal law looks at not at how heritage is viewed globally, but rather the heritage as it is relates to the local population, that is of significance on a local level rather than on an international level, and not to have any hierarchy of what heritage is more significant or more worthy of safeguarding and protection. I think it's very problematic. The new concept of victim to include property or even the environment, this goes to a long-standing and interesting discussion on the anthropocentric focus of international criminal law and on victimhood in particular. I regret to say that I can't see it actually developing, particularly in future litigation, but maybe direct you to the work of Matthew Gillett, who has written on this sort of anthropocentric aspect, and Sophie Starenberg, who is a Grotius colleague, works on it in the context of heritage. On the crimes against the environment, actually very progressively and interestingly, the UNWCC did deal with some cases relating to crimes against the environment, but maybe afterwards we can get more information from Dan and Wolfgang and others who know more about that. Thanks.
Can you answer about the high ranking, because that was also a general question.
The high ranking.
The prosecution of high ranking officials in this context.
Oh, well, I mean, Glenn is more knowledgeable on this subject than I am. If Glenn is saying that low-level perpetrators are being highlighted, or low-level perpetrators are being the focus of prosecutions, I think that is, from a prosecutorial strategy perspective, is not ideal. You want to be building cases towards those who are most responsible if you want to have any sort of deterrent effect, rather than going for the always or more frequently going for the low-hanging fruit. Although there are benefits to doing that in a pyramid based and all that sort of nonsense, but I think Glyn is making an important point, which I think Oksana is best placed to answer. Thanks.
Okay. Thank you very much. I do want to give you the last word, and that's how I'm going to ask Professor Forbes any comment on the questions.
No, I think it's better that.
Excellent. So let's go at it.
Thank you for the questions. I tried to do it very short. Alexandra, as for the effectiveness of international jurisdiction, you mentioned that, the prosecution within the international jurisdiction. I can say that, of course, first of all, we are talking about the prosecution during the ongoing armed conflict, comparing to the prosecution in other tribunals like Nuremberg or Tokyo, ICTI, we are talking about the ongoing and transitional justice now with sui generis as well, because we are trying to prepare the concept of transitional justice processes within the international, not internal armed conflict, and during the ongoing armed conflict. But I can say that I do believe that these arrest warrants were very effective. First of all, because 123 countries they are obliged to prosecute and to surrender the Vladimir Putin and the Maria Lvova to the ICC, and other countries, they can do it. They are not obliged, but they can. And we see that Vladimir Putin is already frightened to go abroad. So it is the efficiency. But of course, during the ongoing armed conflict, we can't expect that he will be surrendered by Russia until the coup d'etat in Russian Federation, for example, or until something happens very fast. So we need to have this patience and to wait until these wheels of justice will cover and will bring some results. As for the criminalization of deportation per se, definitely it's not the international crime. I'm not sure that there is such a necessity, because currently we can prosecute deportation as war crime, as crime against humanity, and they are not mutually exclusive. We can prosecute one action as those crimes, and of course we can prosecute deportation of children as genocide, and not only deportation, transferring of children, but the causing of mental harm as well to deported adults. We can discuss this issue as well. And for me, it's better to focus on efficiency of those prosecutions, not creating new rules, but implementing the existing. As for Glenn's question, thank you very much. I can say that, as to my knowledge, Ukrainian prosecution is not focused on the low-level soldiers. I'm the member of the advisory board to the Office of the General Prosecutor, and I can say that, of course, not. This is not the focus. The focus is to prosecute the high level, the big fishes. It's difficult to prosecute them because we have more than 100,000 criminal prosecutions. I hope this number will become lower after the e-case system launching. It will be like this fragmentation, existing fragmentation, could be eliminated. But the idea is to focus on the high-level officials, and we have several so-called magistral cases concerning the crime of aggression, concerning the genocide prosecution, and currently the prosecutions which were previously qualified as war crimes are reviewing on the genocidal intent. And of course, we're talking about not the soldiers in this regard, not the drivers of the buses, but the high-level officials. As for the command responsibility you mentioned, indeed, we don't have this, again, sui generis concept of command responsibility, superior responsibility in Criminal Code of Ukraine. But nevertheless, Article 438, prosecuting war crimes, is a blanket rule. So it gives the opportunity to apply, actually not to implement, to apply directly the provisions of the international treaties, such as Article 1 of the Hague Convention 1907, Article 1 of the Geneva Conventions 1949, articles of the Additional Protocol 1, yes, thank you, requesting to prosecute all those who committed violations of IHL, for example, in this regard. And it's just, of course, it is the question of the expertise. We need to implement the proper provisions. And it is the draft law which was already even signed by the Speaker of the Verkhovna Rada of the Parliament, but unfortunately not enacted. This changes to the Criminal Code of Ukraine, prescribing the command responsibility. But even now, we can do it without these changes to the Criminal Code, and we are already doing it. of course, and we can prosecute them in absentia. Ukrainian legislation allowed, but to build the case in this regard, it needs more effort than to build the case concerning soldiers. So it is the ongoing process. You know, it's only, of course, it is the 9th year of war, of armed conflict, but it's only the 2nd year of effective measures which have been implemented in this domain, in this dimension of criminal prosecuting. So we are struggling. Do not expect that it will be very fast. It's already going on. Thank you.
Thank you very much. So much more to discuss. I really thank you and thank the organizers and more importantly, the panelists. Please give them a big applause. It's time to discuss with them at the end of the session, but now we will move to the next panel, the rocky road for criminalization and effective prosecution in the hands of Dr. Tarsak.
So in this last panel, we want to pull the different strings together. What can we learn from the UNWCC? What are the prospects also of investigating and prosecuting these crimes domestically? I think there are three main issues, three main areas where we see changing landscapes. One is the area of the crime of aggression, where we see in the Ukraine conflict, obviously new initiative also to prosecute aggression domestically. We have calls for hybrid jurisdiction. We have the debate on ICC amendments. So we have a changing landscape in how we think about, returning to the legacy of dealing with a crime of aggression. The second, I think, major change that we see is in relation to the law of immunities. Here we have jurisprudence from the International Court of Justice, from the ICC, from domestic courts, which are also a critical element, I think, if we look into options for investigating and prosecuting these crimes. And the third one is, I think, what has been already mentioned, the changing landscape in relation to complementarity, in the sense that we see domestic courts also under universal jurisdiction starting more actively to investigate these crimes. At the same time, we still can ask how universal is universal jurisdiction actually, and are domestic courts really adequately equipped to prosecute, international crimes, particularly when it comes to aggression. There might be still some question marks on the universal jurisdiction. So we have, I think, a set of extraordinary panelists who don't need a long introduction. Patricia Griechbeek, who is associate professor at the University of Warsaw. She published books on human and non-human targets in our conflict with COP and on the crime of aggression. So she will speak to the aggression issue. Then we have Pierre Dargent, who's a professor at the University of Leuven, special counsel at Foley Hoag, member of the Institute of International Law, former president of ISO, and obviously a frequent advocate also in cases before the ICJ. And last but not least, we have, I think, Mr. UNWCC, as I will call you, Dan Flash from SOAS and door tenant at 9 Bedford Road. So we will start with Patricia, a little bit with a focus on aggression. Then we move on to Pierre, who will put a focus a little bit on the immunity discussion, and then we move on to Dan and opening up to a general discussion. So Patricia, the floor is yours.
Thank you very much. The rocky road to the criminalization of aggression could be explained. The task was very tough, having in mind that to talk about the crime of aggression, the first thing which you need to do is to define aggression as such. And this was a tricky question raised already in the interwar period, but states didn't manage to define aggression at that time. The only binding definition which we can find, this is regional definition adopted by Eastern European states. These are so-called London conventions. Of course, we could also make a bitter remark that all those states which ratified this treaty and with the Soviet Union, they were almost all of them attacked by the Soviet Union. So these conventions, they didn't prevent aggression as such. And if we are looking for another definition, then we would have to refer only to the resolution 1974. And also one more bitter remark, that the works on this resolution took a few decades, because they started at the end of the 40s and they lasted till 1974. And on the day when this resolution was adopted, nobody was satisfied, but nobody also had enough force to restart the whole procedure. And it is also interesting that when the definition of aggression came up in the negotiations of the Rome Statute, once again states said, no, we are not satisfied with this definition from 1974, we need to negotiate further. But then a few years later, they decided that still we don't have any better idea, so let's stick to the resolution which we already agreed in 1974. But what about crime of aggression? And here, once again, I need to refer to St. James Declaration of January 1942, in which, as you could read, this states, and I would like to stress that this was done not with the big powers, but I would say that against the big powers, and to pressure big powers, to explain them that for those states which are occupied, the priority is to prosecute those who are guilty of war crimes. And by war crimes, those states also meant aggression, because they understood this term very broadly. And within the United Nations War Crimes Commission, the person who raised the issue to prosecute Nazis for the separate crime of aggression, for the aggressive war, was the Czech delegate Boguslav Echer, who in March 1944 presented a report titled Scope of the Retributive Action of the United Nations according to their official declarations. This report was discussed in the committee of UNWCC, and even there was a draft resolution adopted based on this report. But the major powers, like UK, like France, they were against the prosecution for the war of aggression, and they were against the whole idea, while other states, those smaller, they were very in favor, and they managed to convince others to vote in favor of so-called minority report and to pressure to have this crime within the works of the UNWCC. But of course, we know that in Nuremberg, the crime of aggression, called at that time crime against peace, was prosecuted as the supreme crime. So as the most important crime, as the crime from which we derive all other atrocities. And you could also understand that this is also now the reasoning of Ukrainian government, which explains that without aggressive war against us, we wouldn't observe all those crimes, like, for example, deportations, which were described by Oksana. So the crime was prosecuted at that time in Nuremberg, but there was a still long way to understand that this crime should be also applicable to others, so not in such a very selective way. And in the resolution 3314, into which I did refer, there was not much about the responsibility for the crime of aggression. They just referred to this statement, which we could learn from the Charter of the International Military Tribunal, that the war of aggression is a crime against international peace. And one remark, if you now check the national criminal codes of various states, you would find out that still, even those states which are parties to the Rome Statute, if they have criminalization of the crime of aggression in their criminal codes, they do refer to the Nuremberg standard, not necessarily to the standard which was adopted in the Rome Statute. I do refer to the Rome Statute of the International Criminal Court, but this was really very long and very rocky, and still rocky road to have it in the Rome Statute, because in 1998 states could not agree on the definition of the crime of aggression, but they managed to agree that we keep crime of aggression, but we will wait for the definition. Then the Kampala Review Conference. Finally, we have the definition. Finally, we have the conditions to exercise the jurisdiction, but still we are not ready to exercise this jurisdiction. So let's wait for New York decision. The New York decision was taken, but at the same time, the amendments were a little bit destroyed, having in mind what negotiators did in Kampala in 2010. So in result, we have very specific conditions to exercise the jurisdiction over the crime of aggression. The problem is that in case of the proprio motu investigations, or for example, based on the state referral, you need to check that both sides, so the victim state and state aggressor, are parties to the amendment concerning aggression. And you have only 45 states which ratified those amendments so far. Usually those states are not considered as the potential candidates for the aggression. And the additional problem which appeared in case of the aggression of Russia against Ukraine, that even with the declaration of Ukraine to recognize jurisdiction of the ICC, it is impossible for the ICC to prosecute this crime without referral by the Security Council, and you fully understand why this referral is impossible. I must say, so the Security Council, and then you have this definition. This is additional problem because my colleague just explained that there are works even to establish special tribunal for the aggression, and the discussion, if this is possible to have this tribunal, is what kind of standard we should have. And there are several problems related with the definitions which we have in the Rome Statute, that it not necessarily reflects the customary law, having in mind the criminal codes of various states, especially from the Eastern Europe. But also referring to the UNWCC works, now for us, it's obvious that we want to prosecute international crimes based on international law. But during the negotiations in the Commission, many states, including Poland, they stressed that maybe international law is not prepared for the prosecution of those crimes, and maybe it's better to refer to the prosecution of those crimes based on the national law. So, for example, to refer to the to the presentations of Joseph, the question of the destruction of cultural heritage could be dealt properly based on national law, but not necessarily based on international law, and that's why we had so many denials of extradition of people who were accused of this. Yes, but then Carsten just mentioned universal jurisdiction or the even national jurisdiction, we still would have some problems. And these problems would be that, firstly, states are not encouraged to exercise universal jurisdiction in case of the crime of aggression, because definitely the problem of immunity would appear. Yeah. And so I would focus now on this question of immunity and privileges, because this would be also the topic developed by my colleagues. And this is the issue, that if we want to prosecute leaders for the crime of aggression, this would mean, for example, prosecute Troika, which have their privileges and immunities. And it is quite surprising that even after this very long road to criminalize crime of aggression, still this crime is not treated as other core crimes. You could see it in the works of the International Law Commission. For example, in 1996 Code of Crimes Against Peace and Security of Mankind, in case of the crime of aggression, it was emphasized this is such a specific crime that maybe not use universal jurisdiction in relation to this crime. And then nowadays, we have the works on immunity of state officials from foreign criminal jurisdiction. And in the latest report, which is discussed now by the states, the special rapporteur stressed that crime of aggression must be entrusted primarily to international courts and tribunals, given the political implications it could have for the stability of relations between states. And there are very few pieces of national criminal legislation that address this crime. This could be quite surprising for many states which have their provisions on criminalization of the crime of aggression. And that's why you could suspect that many members of the International Law Commission, they protested and they made very strong statements that they cannot understand why, after so many decades of works on the crime of aggression, still we have the situation that so many states doubt whether we can apply the same rules to the crime of aggression. So why in 2023, we still need to discuss whether we treat this crime the same as other core crimes. Still, our panel could answer some questions or maybe provoke statements on behalf of the state, because the deadline is approaching. The 1st December of this year, this is the moment when states still can submit their comments on those articles on the immunities, and emphasize that maybe they have provisions concerning responsibility for the crime of aggression, and they don't consider that crime of aggression is covered by the state's function. Also, I must stress that this year, in June 2023, we have a new Hague Convention, MLA, concerning cooperation on prosecution of international crimes. And once again, states decided that maybe this crime of aggression is a strange thing, because we will not treat it as other core crimes, but if you want to apply the same rules, you can do it, but on voluntary basis. So still, after a few decades of negotiations, once again, because of the concerns of few states, we have the situation that we treat this crime in distinct way, and then we have a problem that we need to fill the gap. But why this moment of the war of Russia against Ukraine is maybe a good moment to rethink all of this? First, to send a clear signal. We treat very seriously crime of aggression, and we don't accept it now and in the future. And let's forget about the past. Let's just change the law which we have now. That maybe this is the moment to send a clear message that no immunity no privileges, no immunity would cover the crime of aggression as such. And it would be also a good signal to those who are still assisting or aiding aggressors, and because they think that there is still impunity. In fact, there is still no responsibility, so there will be no consequences. And maybe it would be good also to define what is our main good which we want to protect by international criminal law. Maybe this good is our peace, our safety, our security. And of course, we also can think about broadening the concept of the crime of aggression, having in mind that many people say that it's outdated. And for example, it would be impossible to prosecute Hamas representatives for aggression against Israel, because Hamas is non-state armed group, and aggression can be committed only by state against a state. So, because I feel this pressure from our chair to be quite fast. With those remarks, I leave the room for my colleagues. Thank you.
I think the history of aggression, its special nature. Antonio Casillas has actually made the proposal. He's argued that the definition of aggression is too narrow and that non-state actors' attacks should be covered as well. So he made that point. I think with several data views, I think the small states, big states divide, what we saw at the UNWCC, we see now coming back in the discussion on hybrid versus international tribunal, right, where we face, I think, similar dichotomies. And the other thing is, I think, while we have the Nuremberg standard really becoming a rule of customary international law, we still see in domestic implementing legislation really different conceptions of aggression. Some states using this broader Nuremberg formula, but some states using the Kampala formula. But here again, there's one of the lessons about, how, like the UNWCC faced, how do we deal with different domestic definitions and how we can achieve, maybe a broader uniformity or harmonization in this sense. And you already made a gateway, I think, to Pierre d'Argent's presentation. Immunity is obviously one of the big sticky points whenever you talk about domestic investigation and prosecution of aggression. And here we've had a lot of development over the past years, and it's wonderful that Pierre d'Argent, who's closely followed and shaped the ICJ work, and who is also very familiar, obviously, with the work of the International Criminal Court, will give some remarks in relation to that. Thanks, Pierre, for joining us.
Thank you very much, Carsten, Excellency, ladies and gentlemen, dear colleagues. It's a pleasure to be here with you tonight. I feel a little bit responsible for the stone in the shoes of those who want to prosecute aggression, because some 22 years ago, I was counsel to the DRC in the infamous arrest warrant case. And therefore, I must take some responsibility for the nightmare that we are facing. This being said, and this is also a conference that very much draws on history, and I would like to contextualize a little bit the case and also indicate how I read the case in its own context. And I think it is, of course, important, and judges know that. They only settle the dispute that is before them. And I think we can have a narrow reading of the arrest warrant case. That's not a way to try to avoid my responsibility in this instance. for having argued in favor of immunity. But I think a proper reading of the arrest warrant case is warranted. No, I'm going to say a few words about the context of the case, and then I come to the content. The context, as you may recall, is the words of Mr. Yerodia, who spoke as chief of cabinet of the president of the then president, first Kabila, the father Kabila, president of the DRC. And Yerodia was his chief of staff, and he said very nasty things against the Tutsis in eastern DRC. The region was troubled by the war that was beginning with the intervention of Rwanda and Uganda. He spoke about microbes that you need to eradicate with method, in a methodological way. He said that Tutsis were on the verge of knowing the fate of the Jews. Nice speeches. And that they were cockroach, etc., etc. As a result of his speech in 1998, massacres occurred in eastern DRC against the Tutsis, and victims of, and you know, Belgium has a large Congolese diaspora for obvious historical reasons, and people representing the families of the victims came to Damien van der Merch, who was inquiry judge at the time at the Court of First Instance in Brussels. Damien was one of my colleagues at the University of Louvain, professor of criminal law also. And they, as it is possible under Belgian law, they asked the inquiry, they set in motion a criminal case by lodging a complaint. And at the time, Belgium, as you may recall also, had a very generous law on universal jurisdiction, adopted in 1993, a law that was specific on two accounts. First, there was no connecting factor whatsoever. The law gave jurisdiction to Belgian courts for the prosecution of war crime, crimes against humanity, and genocide, not aggression. Whatever the crime was, wherever the crime was committed, irrespective of the nationality of the author of the crime, irrespective of the nationality of the victims of the crime, and also irrespective of whether the alleged culprit is found on Belgian territory or not. So that was a very far-reaching understanding of universal jurisdiction. Universal jurisdiction usually understood as a shared competence between states, where each state has the responsibility to prosecute people found on its territory, so that if all states do so, no impunity will exist for those who fled and are responsible for grave crimes. That was one feature of the Belgian law, very, very far-reaching, no connecting factor whatsoever. The second feature of the Belgian law was that it said explicitly that the law, that immunities were no obstacle to the application of the law. Okay, on that basis, Damien van der Merch, the inquiry judge, issued an arrest warrant on 11 April 2000 against Mr. Yerodia, who at the time of the issuance of the arrest warrant had become the Foreign Affairs Minister of the DRC. He moved from, he spoke, when he spoke his nasty words, he spoke as chief of staff. In the meantime, he had become Foreign Affairs Minister of the DRC. And then the DRC turned to a flamboyant French lawyer to lodge a complaint against Belgium before the ICJ. Some of you may recall the name of Jacques Vergès. He was famous for having defended Claude Barbie at the trial in Lyon. He was also the lawyer for the terrorist Carlos. He was a famous, well-known figure in France, a very strange person on many accounts, anti-colonialist from French, Algerian, and Vietnamese descent, very vocal with a lot of mystery and holes in his biography. And so he started the proceedings on behalf of the DRC at the ICJ. He tried to have provisional measures from the court that failed because in the meantime, Mr. Yerodia was not serving by the time the court issued the order on provisional measures. he was not serving as foreign affairs minister anymore. He had become education minister, and the court found that there was no risk of irreparable prejudice for the DRC. And so the DRC was not very happy with Maître Vergès, who apparently was going every second week to Kinshasa to get his money, and they were not happy with the result. And by chance or by the coincidence, and this is also there is, as I said, a big diaspora in Brussels, and there are still close ties between Belgium and the DRC. And I wrote a lot on the Belgian law on universal jurisdiction in a fairly critical way. So they came to me, and I became counsel to the DRC after they sacked Jacques Vergès. And then I turned to François Rigaud, one of my professors at Louvain, who was at the time judge ad hoc at the court in the oil platform case. This is an interesting feature, because at the time he was pleading before the court, he was also sitting with the court in deliberations in the oil platform case simultaneously, and that led the court to adopt practice direction number 8, which says, this is not a good idea to have a judge ad hoc acting as counsel at the same time. And together with François Rigaud, who it was maybe the name is familiar to some of you, he was really a great intellectual in Belgium. He's a private law lawyer, but he was also counsel to Iran before the Iranian Claims Tribunal. Monique Chamier-Gendreau, an old friend of François Rigaud, came also on board of the team, still living, very alive, a former member of the French Communist Party, a great woman with great opinions and strength and passionaria, also anti-colonialist from the first days in the 50s, etc. And it's interesting, I say that because it's interesting, those two people, I don't know where I am on the political spectrum, but François Rigaud and Monique Chamier-Gendreau were clearly the traditional European left, okay, intellectual left of the 60s, 70s, and 80s. François Rigaud at some point was very criticized in Belgium because he sided, my goodness, he sided with the Khmer Rouge, okay? And he said, well, it's not a proof that communism is a failure. It's just the Khmer Rouge who did not read properly what the communist book. So all this to say that there was, and of course you have to take into account also the fact that this is Belgium, the former colonial power, issuing an arrest warrant against the foreign affairs minister of the DRC, the former colony, during the time of war, and essentially sending the message to the Belgian political branch and all over the world also, it is Belgium choosing who can speak on behalf of the DRC to try to broker peace, and who is not going to travel to New York because there's a Interpol red notice on that person. Okay, so the context, of course, of that exercise of universal jurisdiction is worth remembering. Now I turn to the content of the decision of the court. There were two issues at the beginning: universal jurisdiction. Is it an abuse or not? Is it legal or not? And then immunity. As you know, the court never had to say a word about universal jurisdiction. The written pleadings of the DRC contain developments in that regard. And then when Monique Chamier came on board, she was very wise. I was very much in favor of pushing for trying to have the universal jurisdiction law found illegal by the ICJ. And then she was very hesitant, and she said, it's not worth pushing, it's a very divisive issue. We'll have, you know, it's basically going back to Lotus. Do we ask the court to overturn the Lotus case? Because Belgium was saying, which law did I, which international obligation did I breach by having such an expanded version of universal jurisdiction? Can you point at any obligation that prevents me from doing what I'm doing? So it's a difficult legal argument. probably divisive within the court, and also politically, the court was presided by Gilbert Guillaume at the time. Gilbert Guillaume, the Lotus case, the French victim on the Lotus case. And she was, as a human rights person, she was very much afraid that Gilbert Guillaume, being known to be not the most progressive person and fairly conservative, legally speaking, and probably socially also, she was afraid that he would use that case to throw universal jurisdiction to the bin once and for all, to have a very bad pronouncement of the ICJ on universal jurisdiction. So she thought it was not needed to have a good result from the ICJ. It was better to have, for the DRC to have a quick judgment with a deliberation on only one point and not 2 points. And logically, the court would have first to address universal jurisdiction and then immunity. But if we get rid of universal jurisdiction, that could lead the court to issue quickly a judgment favorable, with a large majority favorable to the DRC. So even a wording like the exercise of universal jurisdiction without any connecting factor has no basis in international law, which were the type of framing of final conclusions that we were ready to make. Even that type of language was finally dropped for strategic reasons, as I tried to explain. And then on immunity, and this is here I think that we have to recall and remember that the court was very specific, never addressed whatsoever aggression. The court has a two-step approach. First, there's a rule of under customary international law of immunity. Yes. I'm sorry to be maybe too long. The jurisdiction of the court was founded on the two optional clauses, so it was a very broad jurisdictional base, and the court could have addressed universal jurisdiction and was able to address that very international law. There is immunity for serving foreign affairs minister, and then it addresses the exception, and the exceptions is specifically the question addressed by the court by the exception is specifically limited to war crimes and crimes against humanity. The court has been unable to deduce from the practice that Belgium presents that there exists under customary international law any form of exception to the rule according immunity from criminal jurisdiction and inviolability to incumbent ministers of foreign affairs where they are suspected of having committed war crimes or crimes against humanity. Therefore, the court did not look in any way to the question of aggression, and the judgment is without prejudice to the possible exception in relation to aggression. Now, as you know also, and I'm going to move quickly, as you know also, the court made some exceptions to the possibility of suing before the domestic courts of the responsible minister if the home state waives, if you are before an international court having jurisdiction. And then the court said also, provided that it has jurisdiction under international law, a court of one state may try a former minister of foreign affairs of another state in respect of acts committed prior or subsequent to his or her period of office, as well as in respect of acts committed during that period of office in a private capacity. And at the time, there was no clear distinction yet between ratione personae, ratione materiae, immunity. But those words, provided that it has jurisdiction under international law, clearly addresses indirectly the Belgian claim of universal jurisdiction, because at the time the court spoke, Mr. Yerodia was not even Minister of Education anymore. And it was entirely possible that the day after the issuance of the judgment by the court, the Belgian inquiry judge would launch a new arrest warrant, okay? And those words are somehow preventing, in a way, that possibility. Now, let me. I spoke 15 minutes. It's time to conclude. All this to say that I think we need to think out of the box, and I think we don't need to take the arrest warrant case as a case that prohibits a further understanding and a better understanding, or at least the making of some arguments. Now, one word on aggression. I think we need to take the temporality of aggression into account. For me, Ukraine, for instance, as the belligerent against the Russian Federation, has the right to kill President Putin under the laws of war. And it would be absurd not to be able, when you are able to kill someone, not to be able to put that person before a court of law. The question is, that is the right of Ukraine, probably, to prosecute the president because hostilities are going on. The question is, what about after the hostilities? Is it because you started that you can continue? And what about the third states? And there, for the third states, we have the tool of Article 41, maybe, you mentioned it, Patricia, the prohibition of aiding and assisting, the obligation to cooperate with lawful means to the suppression of the ongoing wrongful act. So I think those are possible avenues to address the question we are facing today. But again, I think we also need to think about the specific temporality of aggression compared to the temporality of war crimes or the temporality of war of crimes against humanity, which is fairly different. And the real question for me is the obligation of third states after the hostilities have ceased. And in that regard, maybe the arrest warrant will kick back again. Thank you very much.
Thank you very much, Pierre, for shedding light on the Redfern case, for maybe slightly a constrained reading of it. Sometimes you said maybe it's good if the ICJ doesn't rule on certain questions, so maybe it's good that we don't have a verdict from universal jurisdiction, right? Absolutely. Looking at this precedent, and I think your third point about the temporality of aggression, what about the in-conflict, post-conflict distinction, how does it impact investigation and prosecution in third states, I think is again an important point that you mentioned. So now he was already very anxious, getting a bit nervous that he won't have any more time, but now finally Dan Plash with the concluding statement of this panel. Thank you.
Thank you so much, and to thank Pierre, Patricia, Carsten for this panel, and everyone, and your staying power. And I know that's in the dangerous position of standing between you and a drink. So hopefully I can keep you in your chairs for a few minutes longer. In a minute, I want to come and engage with the immunity question. But I just, for those people who are perhaps looking for further study or dissertation topics, just to delve into our website and what might be available to you. Never mind indictments, and there's a question of whether the UNWC amounted to anything. If you look here, these are the trial transcripts and reports of individual nations back to the Commission in London after they had originally submitted their indictments to the Commission and sought a prima facie magistrate's approval that there was a case to answer. And then subsequent to that, trials were conducted. And in the Anglo-American tradition of establishing a customary law, these were then reported back to the body. And you see in the Yugoslav Tadic case and others, some of the 15, as they're called, the 15 volumes, they're not very big, the 15 volumes of some 70 cases that the UNWCC published just as it was being shut down in '48. They're in a rush. But these are the full trial reports, which will be in National Archives, but also are here for your delectation. And if you look, you see there are some, and this goes way beyond the Control Council provisions, there are some 500 full trial transcripts of British military tribunals in Europe and the Far East of Nazis and Japanese personnel. You see that there are some more and more, they're quite loquacious, the Americans. There are some 600 transcripts of US JAG tribunals conducted in Europe and the Far East. Some of them, famously, Kevin John Heller's great book on the subsequent proceedings at Nuremberg are here. And unfortunately, Kevin wasn't aware that the prosecutors in Nuremberg sent all of their cases to London for a consideration by and judgment of the 16 countries, which, by the way, included nationalist China and India, sitting looking at American cases as to whether or not they met a prima facie standard. So I commend those to you. Further, I would offer to you, excuse me, one or two of the Commission's reports. The history, which actually in Chapter 9 deals with the immunity question and describes in some detail how a number of states brought the issue of head of state immunity to the Commission in 1944, and after some lengthy discussion, which they outline, but again they were writing their report knowing that they were about to be shut down by McCarthyism, to be brief and blunt about it, and in the end approved some cases. And we'll come to those in a moment. But one particularly interesting report I commend to you is a report that they were commissioned to write for ECOSOC in the UN in 1948, which deals with questions of fair trials, the rights of the accused and so forth, and reflects the practices of the Commission in the preceding 5 years, and speaks very much to the question of how far this was meeting an acceptable standard of legal practice. And this paper is a little counterintuitive to the standard historiography and bibliography of what we think about the time, that frankly one doesn't really expect to see a 300-page document written in 1948 about the relationship of human rights to war crimes trials. But nevertheless, there it is, and I do commend it to you in your scholarship. So, coming to the issue of immunity. Amongst the archival material, and with colleagues, some here and some not, we've done some work recently on the cases that the Commission considered under the immunity topic. And what we find, and this doesn't include the cases brought by Ethiopia and approved by the Commission in 1947. That is a slightly separate matter, but there are in fact 10 detailed cases brought by Addis Ababa, approved by the Commission in 1947, but with many of the accused being close to the new Italian government, the Anglo-Americans prevented extradition as was provided for under the treaty. You perhaps can hopefully see these texts a little, but you can bring them up on your own devices. What we find is that the Commission, as I mentioned, in its history in Chapter 9, did explain that it discussed the issue of immunity and decided that it was legitimate under customary international law. And bear in mind that this body is at this point chaired by a former president of the Permanent International Court here in The Hague. He was in 1936, Sir Cecil Hurst. Subsequent to that judgment, and we have them both as one, I think, a 900-page document, but also you'll find the links here will take you into individual cases. What you find is that First of all, Poland indict Adolf Hitler and his henchmen for a whole wide variety of crimes. Time and circumstances don't permit me to go through them here today. In the fall of 1944. And shortly thereafter, the Czechs, who clearly had been working hard at this issue for some time, produced, I think, 13 different charges against Hitler and his entourage for crimes as varied as the illegality of the Nazi courts in Czechoslovakia, the extermination of the Jews, a number, understandably, about the exterminations associated with the massacres at Lidice, which still resonate in history and in Czechoslovakia in particular. And then in the spring, this brings us back to Pierre, in the spring of 45, Belgium brings 3 cases against Adolf Hitler. And by the way, all the others have been approved, but considered and approved by the Commission. And you will find on our website the correspondence between the Commission and the national offices of the states concerned, confirming that the cases have been reviewed and approved. So we have the the connection there. And the Belgian charges, and by the way, the Czech charges run to 50 to 100 pages each on some dozen different charges. And the Belgians similarly go into very considerable detail. And I find it slightly strange, given the topic this evening, and indeed going back over the decades, that there is this apparent amnesia in Belgium to this day, not only about its great leadership in the Commission in general, but also that they didn't draw upon these cases in the matters they brought to the ICJ some 20 years ago. I also find it slightly odd that the Commission chaired by a former president of the ICJ is completely ignored when the ICJ decides that there is no customary international law. Given the criteria that the ICJ sets out for itself about what it considers constituting international law, that is the practice of states. Well, we have 3 states carrying out, bringing indictments. We have 16 states approving them, and the level of expertise and jurisprudence from René Cassin to Cecil Hurst involved in supporting them. Quite why the historical and legal community have such extensive amnesia, I'm just a simple historian and sometimes nuclear weapons analyst, finding myself by accident in this particular field of research. But it does seem to me slightly odd that this material is so overlooked by those who seem to be so concerned about it. And the Belgian cases, going back to the earlier panel, range from Auschwitz to pillage. Again, I very happily come back here and run some classes and take people through this, and there are plenty of dissertations to be written. But Hitler is indicted, and the indictments are supported by Belgium for pillage, as well as for the extermination of the Jews. And as I say, the cases brought by Czechoslovakia are very, very are varied as well, from legal technicalities through to mass extermination. And I would say that the Czech cases and the Czech protagonists were either ostracized or indeed, as Dominika educated us recently, were in fact murdered by the Czech government, the communist government, in the later 40s. The Czech cases are, I think, a model of bringing forth detailed evidence. And by the way, again, if you look at the quality of evidence, there are large numbers of affidavits populating these cases, not just the immunity cases, but in general. It isn't simply a question of lesser qualities of evidence, and indeed also, one might say, confession statements by officials that so-and-so will be murdered, executed without trial, as a public statement in newspapers in occupied Europe at the time. Confessions, if you will. So I would suggest to you that where we look at prosecutions by Ukraine against Putin, whether we look at other issues that within the scope of universal jurisdiction and more broadly, that there is a very considerable body of legal practice that supports the idea that there is indeed a large body of customary international law validating the indictment and prosecution of leaders. Now one can say, well, of course, Hitler died. Well, I don't think anybody says with respect to current leaders under indictment that because the cases have not come to court, they have no validity. But let us say you want to take that time. You only have to look in the appendices to the UN's War Crimes Commission's own official history, which has only been a public document since 1948, and find in there the list of those top Nazis around Europe who were convicted of a variety of crimes. Now one can say generals, they don't rise to the status of national leaders. But the Gauleiters, that is the proconsuls of Poland or other occupied territories, territories incorporated into the German Empire, certainly meet that standard. And this takes us well beyond the people who found themselves in the dock at Nuremberg. And one can say, well, think about the national military tribunals the Americans ran at Nuremberg. Well, yes, but these cases were brought by the United States to the Commission. They can't be considered as separate to the custom and practice of the Commission. So I would say this is an illustration that there is not simply, as Carsten as Wolfgang Form said, a treasure trove, but an entire mineral field for research and exploration of direct and immediate relevance to the issues that concern us today. I appreciate your patience this evening and throughout the afternoon. Thank you very much.
Thank you so much, Dan. You're the living history of the Commission, I would say, to some extent. Before opening it up for one or two questions, I would like to give the floor to Pierre, maybe to respond to the Belgian.
I don't need to respond or to defend Belgium. I think the difference, and I mean, that was a situation of co-belligerency. That was a situation of a relationship between enemy states. And of course, the situation in the arrest warrant case is completely different. There is no base. Ukraine has a belligerent relationship with the Russian Federation. And my argument would be in that to say that because of that relationship, Ukraine can waive the immunity, or rather the immunity of the president is not opposable to Ukraine in those situations. There is, fortunately or unfortunately, no other co-belligerent with Ukraine. If there were, those states would be in the same situation as Ukraine, I would argue. And that practice would be extremely useful to establish that right of co-belligerence to ignore possible immunities. But and arguing the case, the arrest warrant case for Belgium was Eric David, the late Eric David, who passed away a few weeks ago. And Eric, I think he knew those, he was aware of the work of the War Crimes Commission. But I think it's true, you're right. The War Crimes Commission work was not referred in the written pleadings of Belgium and neither in the oral presentations by Belgium. But I think, and I suspect, the reason is because of the belligerency relation that was the basic assumption under those indictments by Belgium, Czechoslovak courts, and others. That would be my argument. And I think for that reason, the crime of aggression is a specific crime in that regard compared to the other crimes under international law, because there is a state-to-state relationship.
I'm tempted to say I'll buy you a beer if you can find me any Belgian international lawyer who's even heard of them. Not my commission, but their commission. Their own work.
No, thank you, Pierre. It's indeed an interesting interpretation that you give. I mean, some would argue that aggression should be treated like the other crimes, so you would not need necessarily that relevant nexus in order, in order, not to be able to claim immunity. So it's pretty much, I think, a dividing line between how you view aggression as a crime and this traditional notion of aggression as a sovereignty crime, I think, has come a little bit more under critique with the human security reading of aggression. And once you adopt that human security reading, then the question is, do we need that belligerent, relationship,
Yeah, maybe we don't need it, but it exists under international law, does it not? I mean, you are in a situation of self-defense. That's a right under international law that does not belong to those who have not been aggressed. And you may join in an effort, in a solidarity effort, in collective self-defense, which creates another co-belligerent relationship. But
under the law of self-defense, yeah. But somehow everyone seems to have forgotten universal jurisdiction as being useful in this regard. But I do find it odd that one can still, perhaps, I'm not sure if you are saying this, still say that there is no customary international criminal law with respect to these issues, because demonstrably there is. You can argue up and down whether it's particularly relevant to this case or that case or the other. But to say that these 15 cases brought by 3 states, approved by 16 countries, are invisible.
No.
And I think it's a problem for your industry that it is a simple historian such as myself who has to bring it to your attention.
We are idiots.
Are you on the record?
Okay, I think it's open up for 1 or 2 questions. So please, of course, yes.
You're laughing. I'm so gratified.
Thank you very much. I have 2 questions. If I may, one to Patricia. Correct me if I'm wrong, as to my knowledge, the FJ already acknowledged the resolution, the definition in the resolution, such as Greek team and the customary rule. So possibly it's now room for discussion about the interpretation, this implementation of Nuremberg provision to national legislation, if we have the decision of ICJ, or you can interpret the collision between the ICJ decision and the national legislation, taking into account that national legislation, nationality and the customary rule is higher than ICJ decision. And I would also like to ask Pierre, if I may, about the erga omnes obligation. Is it a referenda at all, or is it an obligation? Just
which erga omnes?
Erga omnes concerning the prosecution of the crime of aggression. It's the preemptory rule of international law. So we have this obligation of all the states. Possibly, of course, it's better to have this erga omnes partes obligation just to show, but no one doubt that the crime of aggression violates the UN Charter. And possibly it's and especially taking into account the ICJ opinion in 2 cases that it is the violation of customary rule. In case of non-belligerent state, it's also the obligation to prosecute for the crime of aggression. Thank you very much.
So we have another question here in front, yeah.
Good evening, everyone. My name is Yin Han, a student at Leiden University, majoring in international criminal law. And in Myanmar decision, the judge implies objective jurisdiction or even their effective control or non-state party. I want to ask whether it is possible to apply this jurisdiction over the crime of aggression or other co-crime in the future inside of universal jurisdiction. Thank you.
Can you just formulate it in one sentence, maybe?
Repeat my question.
Yes, in one sentence, please.
Yes, whether it is possible to apply the objective territorial jurisdiction or even the effects doctrine over the crime of aggression or other co-crimes in the future instead of universal jurisdiction.
Okay, two easy questions at the end.
I'm not qualified to answer your.
So, oh, shall I?
Have we finished with that?
So.
You had your time in the sun, President.
I have a footnote for the discussion on Belgium. I think it's dangerous to look at Belgian practice if you're interested in consistency in international law.
I know.
50 years ago, in the General Assembly, when the Apartheid Convention was being adopted, which is the one international criminal law treaty that pretty explicitly recognizes universal jurisdiction, it was Belgium that took the floor to protest and object to the idea of universal jurisdiction.
Well, IDs can change. And I don't take responsibility for the laws of my country.
The question about the ergonomist nature of the crime of aggression. I think.
Well, yes, the crime of aggression is ergonomist. So any state may invoke the responsibility of the aggressor. The obligation to prosecute, you say it's an ergonomist obligation. There is nevertheless some allocation of primary responsibility, I would say. I'm not sure that because the crime of aggression is ergonomist, there is an obligation to prosecute again if the situation for the triggering of that obligation exists. But the triggering of that obligation, I would say, in universal jurisdiction is triggered when you find the person responsible for the crime on your territory. But prior to that, the obligation is not yet set in motion, I would say. And for the crime of aggression, at least that's what I would say, generally speaking, for the other international crimes. But I'm not sure that there's an that because one state is the aggressor and the other state is the victim state, all other states in the world must start prosecuting the aggressor. Right? On what basis? That I don't know. Is there as an obligation, maybe as a freedom to do so, but and that would be Belgium, but as an obligation to do so. I'm not sure.
Can you help with the second question? Because
I'm not sure I can help with the second question. I'm not sure I understood correctly your question. Your question was, can we replace the title of universal jurisdiction by territorial? Okay. What is behind your question? Why do you ask the question of replacing universal jurisdiction by?
No, not to replace, just to apply the objective territorial jurisdiction, such as in the Myanmar area, over non-state parties.
Apply?
Myanmar criteria runs. Results.
I need to think about that.
Transport. So I mean, sorry, most states limit, of course, their jurisdiction of aggression still to territory and nationality. So there are only a few states which have universal jurisdiction. So I don't think it's included that you could invoke the effects doctrine necessarily. But I mean, if you have universal jurisdiction, of course, you will not need it. And the question is, how far do states are willing to extend their jurisdiction? And what you see, unfortunately, is that in the reality of states, aggression is still treated as a different crime than the other core crimes because of that interstate nexus. This is why states have been more reluctant to extend universal jurisdiction to aggression. And so it will be a long process, I think, until this will happen. But Patricia, you've looked at this particularly.
So
one thing about the judgment which Pierre discussed, I think that we need to remember that still, I know that the common law lawyers, they pretend to ignore the fact that those judgments are not precedents, but they are just binding between parties to the dispute. And still, if we look into the judgments, we could find the guidelines made by the court, which says these are the states which are making the law. So we cannot predict in which direction the law would go. If you want, you can change the law, but give me this practice which I can assess and tell you that, for example, it doesn't apply. So that's why I'm talking about this Ukrainian momentum, because this is maybe the time for the reflection for states in which direction they want to go. It doesn't need to be attached to the judgment from 2002, but they just need to have a conscious decision in which direction they want to go. And relating also with your question, but the universal jurisdiction raises some doubts and you have different opinions, but you can overcome this problem. And one proposition was made just by Polish prosecutors, which decided to open investigation concerning crime of aggression committed by Russia against Ukraine, but not based on universal jurisdiction, but based on protective jurisdiction. And by stressing that, sorry, this war is not just affecting Ukraine, but it is against world peace and security. So it's also against the basic interest of Polish state. And with referring to your question, yes, I do buy your argument that if we treat prohibition of aggression as peremptory norm, and we have a special obligations which Pierre just mentioned to bring this to the end, if we link it, for example, with the resolutions of the General Assembly, which explicitly said you need to bring the perpetrators of crimes to the justice, then combining all those statements, you can build the case. I'm not sure whether we would convince everyone, but at least you could try.
Thank you so much. I think we've seen that after 80 years, many of the questions that the Commission has been debating are still looming today. So we hope that we've shed some further light, I think, on some of these issues. And we now have an opportunity, obviously, to discuss issues further over drinks, which are on the second floor. So, but before closing, let me first of all, again, thank our organizers, Paulina and the team. Katie, who's been helping and of course our wonderful chairs and panelists, I think some of them coming from out of town. So thank you so much, I think, for really fruitful discussion and help that develop.